到的状况，如果是10分钟以到，其实就可以到了，就可以说，比如说3分钟或1分钟，3分钟。
所以董执行长
现在刚好31分。
好，我还是希望刚刚有请他们往中间坐，对不对？
对，有。
对啊，因为这样视野会比较好看，我只顾中间。报名的人就是很多，可是不知道为什么都 delay， 所以到时候拍照尽量就往中间拍。就是往很多地方拍就可以了。
不要用广告。
我再确认一下，所以蒋老师还没来，
对，
陈老师还没来，
陈振宇要11点多才会来，所以他确定不会大合照。陈振宇确定不会大合照，对对，
上高铁。
对，陈振宇确定不会。
然后董执行长也还没来，
所以现在就只差吴全峰，
对，
就上去就好了。
好，
那董先有人在做 follow 后吗？有人在后他，就是董先生。
哦。
有人认识他吗？
Distinguished guests, ladies and gentlemen, good morning. The International Symposium on AI Research and Law will begin in 3 minutes. Please kindly take your seats as soon as possible. To protect yourself and the others from the COVID-19, we kindly suggest everyone to wear a mask at all times during the event and remain social distance if possible. Also, a friendly reminder that no food and drinks is allowed in the venue. Thank you for your cooperation. Also, the symposium will be in English and provide simultaneous interpretation on site. You may rent an interpretation headset with your photo ID at the service counter right at the entrance of the venue and select channel 1 for Mandarin. Thank you. Ladies and gentlemen, the International Symposium on AI Research and Law will begin in 1 minute. Please take your seats and kindly turn off your cell phone or switch it to silent mode for the whole conference to move on smoothly. Thank you very much for your cooperation. Distinguished guests, ladies and gentlemen, good morning. Welcome and thank you all for joining us in person and virtually in the International Symposium on AI Research and Law, organized by Taiwan AI Center of Excellence of National Science and Technology Council. My name is Maggie and I will be the MC for today. Artificial intelligence has become a significant driver of forward-looking research, fostering innovation in a wide range of industries, and also raising concerns about governance issues. Governments and private institutions have been exploring the legal framework which is required for the development of AI research, aiming to enhance the accountability and trustworthiness of artificial intelligence. In today's event, U.S. legal experts are invited to share their experiences and insights with regard to the subject, and also to engage with domestic scholars of AI regulation and medical AI to discuss practical AI applications on the topic of medical data governance, and to map consensus in AI ethics and legal system that is required for smart medical research. Today's symposium is divided into the morning and afternoon sessions, both of which comprise keynote speeches and panel discussion that focus on collaborative development of AI research and regulation in the age of smart medicine. And now, to kick off, I would like to invite Professor Jen Yongzhen Xu, the Vice Chair of Taiwan AI Center of Excellence, to come up to the stage and give us the opening remarks. Ladies and gentlemen, please welcome Professor Xu.
Distinguished speakers, dear colleagues, esteemed guests, ladies and gentlemen, good morning. On behalf of the Taiwan AICoE, I would like to welcome give you a warm welcome to all of you for joining us in Tainan today. As we witness the proliferation of AI applications in our daily lives, it has become increasingly important to address the issues of AI governance, such as data bias, privacy, ethics, accountability, and trustworthiness. Having recognized its importance, governments worldwide are incorporating AI governance into laws and regulations. To promote ethical and humanistic development of AI capabilities in Taiwan, NSTC established the Taiwan AICoE with 3 key strategic policies: science and technology research, talent cultivation, and AI governance. So our mission is to establish partnerships with countries sharing similar values to create more impact for global good. We encourage Taiwan scholars to participate in international initiatives on human-centered AI, such as the Global Partnerships on AI, GPAI, the UNESCO International Research Center for AI, and others. This symposium today is part of an event series on AI governance hosted by Taiwan AICoE, aimed at establishing a dialogue on AI research and law, and promoting consensus on the ethical and legal requirements for AI development from a cross-disciplinary perspective. The focus of this event is on the practical issues of medical data governance, as well as the ethics and regulatory consensus required in the age of smart machines. These dialogues will guide the development of domestic medical AI, integrating humanities, regulations, and data governance. We are very honored to have several internationally renowned experts in AI ethics and law as our keynote speakers, Professor Frank Pasquale, Professor Ashley Dix, and online, Professor Danielle Citron and Professor Ryan Calo. They will share their experience of AI governance in the United States and more. We hope this event will promote further discussions and collaborations in the future. So once again, I would like to express our appreciation for your participation and your support for Taiwan AICoE. We wish you a very successful event today. Thank you.
Thank you so much, Professor Xu, for the warm speech. And also, please stay with us on the stage. As now, before we officially begin today's keynote session, I would like to first invite, to take this very special opportunity to invite our in-person and also online distinguished guests and speakers today to have a virtual group photo together. So first, may I invite our on-site distinguished speakers to come up to the stage, Professor Frank Pasquale and Professor Ashley Dix. Welcome, let's join on the stage. Okay, and now as Professor Pasquale and Professor Dix are stepping onto the stage, I would also like to invite our online speakers, Professor Danielle Citron and Professor Ryan Calo, perfect, to also join us on the photo session. Okay, and for now, I would like to invite our distinguished guests from Taiwan to also join us for the photo session. So let's welcome Professor Jingyi Liu, Professor Pau-Choo Zhan, Professor Albert C. Yang, Professor Chuan-Feng Wu, and last but not least, Professor Zhao Tianzhang. Let's welcome the above distinguished guests to join us on the stage. And in this very outstanding and precious opportunities, we are very glad to have all the speakers online and on-site to join us in this photo session together. Okay, everybody, you can take off the mask, perfect, for now for a second. And everyone, let's gather a bit closer. Okay, so for Professor Citron and Professor Calo, please look into the camera and show me your biggest and warmest smile. Okay, so everybody, let's look to the front, to the camera. Okay, ready, set, smile. Okay, thank you very much. Okay, so now for the next one, we have a go-to pose in Taiwan, which is to have one thumb up. So everybody, for this photo, let's thumb up together. Okay, perfect. Yes, and also Professor Citron, Calo, join us for the thumbs up. Perfect. Okay, everybody, let's look to the front. Wonderful. Okay, so for the next photo, please stay with us on the stage for a moment. Let's follow our cameraman and look a bit to the right. Yes. Okay, so we are now going to take another photo from a different and wider angle. Everybody, stay your smile. Okay, everybody, for this one, thumbs up together. Yes, Professor Citron, Calo? Yes, perfect. Wonderful. Okay, thank you very much. Thank you, all the speakers. For our on-site participants, you may remain to your seats. And thank you, Professor Citron, Professor Calo. We look forward to your presentations later on. Thank you all for joining us today. Thank you very much. Oh, what is happening? Sorry, it just happened that we have a small guest also on the stage, which is a very cute gecko. Okay, so for now, let's just wait a moment to see off our little special guest. Okay, very cute accident. Okay, so now we will resume to our schedule. Okay, so moving on, we will begin the keynote speeches of the morning session. For the first presentation, we are honored to have U.S. legal expert, Professor Danielle Citron, to be our speaker. Professor Citron is the Jefferson Scholars Foundation Schenck Distinguished Professor in Law and Cato and Chapman Professor of Law at the University of Virginia. She serves as the inaugural director of the UVA's Law Tech Center and is also the vice president of the nonprofit Cyber Civil Rights Initiative. Her research specializes in privacy, feminism and the law, civil rights, and administrative law and regulation. And today, the topic she will be sharing with us, which is also the name of her latest book in 2022, will be The Fight for Privacy, Protecting Dignity, Identity, and Love in the Digital Age. And now, without further ado, please join me in welcoming Professor Citron. Hi, sorry, Professor Citron, I'm afraid you haven't turned on your mic.
Of course.
Yes, thank you for that.
Thank you. Thank you so much for having me. I only wish I could be there in person with all of you. I'm going to lay some of the groundwork. I know most of the conference is focused on artificial intelligence and then the applications in the medical sphere. And what I'm going to do is talk a bit about the data that's collected that's going to be run through AI systems and make decisions about people. So I'm going to talk about intimate privacy, the privacy that we afford our bodies, our health, our innermost thoughts, which of course we document all day long as we browse, click, and share, our sexual orientation, sexual activities and gender, and our closest relationships. All day long, as we go about our business, we hope, we expect, and we deserve intimate privacy. But unfortunately, it's often not ours. So as we go to the bathroom in a public restroom, we're not expecting that anyone is recording us there and uploading then, what we're doing to the cloud. As we're in our kitchens and we're talking to our Amazon, our Alexa Echoes, we're thinking that everything that we're saying is between us and Amazon. As we browse the internet, as we search, as we go to adult sites, as we use dating apps, as we use period tracking apps, all the while we're thinking that no one's interested in what we're doing, that all the data that is collected about us is between us and the companies, that our tools and services that have assured us that they're there to make our lives better. And we're not expecting, nor do I think we want, all of that data to be not only collected and stored, but also shared, sold to advertisers, marketers, and data brokers. So what I'm going to do is first describe a bit about why intimate privacy matters, how it's invaded by individuals, companies, and governments, how law woefully underprotects so much of it in the United States and globally, and how we ought to think about intimate privacy as a moral right, as a civil right, and as a human right, and how we might go about doing that. So, why does intimate privacy matter? Why do we need privacy with our bodies, our health, our closest relationships, our sexual activities? And the first has to do with autonomy and identity development. When we have the space to go backstage with ourselves and with others, right? Privacy isn't an I, it's a we. But when we have that space, we can figure out who we are, right? We can experiment, we can play with ourselves, our identities, and figure out not only who we are today, but who we want to be. And intimate privacy is the foundation of human dignity. And by that term, I mean social esteem and self-esteem. So when we think we're in charge of who manages the boundaries around our intimate lives, when we think it's us, right, we get to enjoy a sense of self-esteem. And social esteem, a predicate to having others view us as fully integrated people, is that the parts of ourselves that we share, not only do we have decision-making in that, but also that we can be seen, we have opportunities to be seen as full human beings. And when our body parts are posted online, people just see us as fragments, right? We become objects. We're no longer subjects. And intimate privacy goes hand in hand with intimacy and love. Charles Fried, I have to say, said it best when he explained that privacy is the oxygen for love. We know that we form close relationships. So it's not just, of course, our love relationships, our family and our partners, but it's our friendships. And we develop those relationships by essentially unpeeling parts of ourselves over time. And we're only going to do that. We're only going to be reciprocally vulnerable to each other if we trust those other people to treat our information as we hope rather than as we fear, right? To be discreet, to keep our confidences. And without that sense of trust, without that sort of confidence that others will be discreet, we shut down. We become unable or unwilling and frankly smart enough. We don't want to share information with people we don't trust. And so intimate privacy is sort of a predicate to falling in love, to forming close friendships, for becoming a we and not just being an I. So, intimate privacy, I wish I could say like I snap my fingers and we all enjoy it, right? But I'm going to talk a little bit and provide some examples about how individuals deprive us of intimate privacy, how everyday companies, all those tools and services that we use do deny us intimate privacy, and how governments do as well. So I'm just going to give an example. I think, the best way to often for us to feel and understand wrongful behavior and experience and feel the harms is to give some examples. Joan was a recent grad of law school, and she was on her first big deposition. She went with a partner to a different city, and so they each stayed in separate rooms, but in a hotel. And 2 days later, she got back home to her city, and she got an email in her inbox, and the email said it came from an email address that said the address's name was not a bad guy to. And in the body of the email was a link to Pornhub. And that link was a video of her showering and urinating in the hotel room. And included in the body of the email was a message that said, send me more nudes and send me a video of you masturbating. And if you don't, I'm going to send this video to all of your LinkedIn contacts, to all of your friends and loved ones. It's going to be all over the internet. And he says, do this within 24 hours. Now, Joan does not send more nudes. She talks to me. I explain you're not doing any such thing and let's see what happens. And the person makes good on the threat. So sending an email that looks like it comes from Joan. So the email is sort of a spoofed, it looks like her full name. The email includes a link to the video that's posted on Pornhub. And the email says, look at me in my natural state. This is how I love to be. And the person sends it must have mined all of her contacts on LinkedIn. So that include so many of her classmates from law school, her friends at her law firm, her partners, the associates she worked with, all of her kind of professional contacts were sent this video and looked like it came from her. Not a bad guy too, also then blanketed the internet with the video. And the video had her full name embedded in the title of the video. Some of the sites that the person posted it on were like adult finder sites. So suggesting that she was interested in sex and providing her home address. Others were just simply adult sites and crucially non-consensual intimate imagery sites. There are over 9,500 sites whose raison d'etre is intimate image abuse. Most of them are hosted in the United States or the Netherlands. And why? Because they're immune from responsibility in the United States. Their specialty is hosting user-generated intimate imagery. And it wrecked Joan's life. So it took her about 3 years for her to even kind of feel somewhat normal again. She did everything that she could to try to take the video down, but site for site, most ignored her requests. The only site operator to respond was someone who was located in Russia, and the response was, if you send me more nudes, I'll take the photo, I'll take the video down. But for the most part, the site simply ignored her because they could, because they were immune from liability thanks to a federal law called Section 230 of the Decency Act. And it kind of shook her to the core. She explained to me, when she went and told the partner she was working for what was going on, the person was incredibly lovely. But she saw herself through his eyes. And she thought, he'll only ever see me as a vagina, right? As a naked body. It was very difficult for her to get a sense that others were seeing her for who she was. And she said that she lived kind of on a knife's edge because she thought she was in the top 10 of her class. She went to a top 3 law school. Her sense was she could apply for a clerkship and get one that she wanted, but she didn't apply because she thought, how am I going to have to explain this to a federal judge? And she thought every day was her last at her job. You know, she felt so incredibly nervous about keeping the very job that she had fought so hard, you know, of course, to get and to cultivate. She was supposed to get married the year that it happened. She and her partner put off their wedding for 5 years. So it was, as so many victims of non-consensual intimate imagery have said to me, like an incurable disease. You know, she felt like she didn't own her body anymore. Joan's story is one of so many. I interviewed 60 people for my book from around the world. So I interviewed individuals from the United States, UK, Australia, Iceland, India, and Australia. And the story was the playbook is so often the same. So now for companies as privacy invaders, I often call them spying Inc. because it's perfectly legal, especially in the United States. The tools and services that we embed in our lives, our cell phones, our mobile apps, all of our personal devices, the websites that we browse, the search engines that we use, as long as all these tools and services have privacy policies and don't lie to us, it's legally permissible for them to collect, to share, monetize, exploit, and amass hordes of the most intimate details of our lives. And that includes, of course, our dating apps, including, you know, all of the information that we share on those dating apps, our searches on adult sites, how long we spend on a video. It includes, you know, basically our geolocation that our cell phones and then our mobile apps extract. And all of that information, so long as companies don't lie to us, they can share it with marketers and advertisers, which they do. And marketers and advertisers then sell it to data brokers. Now, data brokers, they're about 4,000 companies, often with global practices, and they have about 10,000 data points on each and every one of us. Now, you might think I'm not that interesting. Like, how is it that there are 10,000 data points on me? But the truth of the matter is that everything we do, all of that, what we do, we are ranked and rated and scored based on our activities. And so those 10,000 data points might suggest that we've been a sexual assault survivor, that we have type 1 diabetes, that we are a high likelihood of getting certain forms of cancer, that we're an avid sex toy user, that we watch certain types of porn. That is, if you can imagine us being data points, there are a whole lot of data points that make up who we are, what we do. We don't see them because you don't have a data broker dossier sitting in your lap. You can't understand the extent to which so much of our data is collected about us, exploited, sold, and this will tie into the theme of AI. That data is being mined and pattern recognition used to make decisions about hiring by third-party hiring services, to increase our life insurance premiums, to make decisions about us at work. And all of that data dictates the arc of not only who we are, but what we can become in the marketplace. And, you know, governments aren't, they dipping their fingers in the data honeypot as well, and exploiting data, much in the way that both individual and corporate spies are. So, you know, Rana Ayub was a journalist in India, and she poked the bear of the Modi regime one too many times. She was a fierce critic of their human rights abuses. And in April of 2018, the Modi regime, she got a text on her phone that said, check your phone in about 5 seconds. It's dropping. And this was from a source inside the Modi regime. And what then was released online was a deep fake sex clip of her engaged in a sex act she never engaged in. And it spread around the internet and went viral within 48 hours. So it was on like half of the phones in India. So basically, as a Muslim woman living in her 30s, living with her parents, what followed was a tsunami of abuse. Her phone number, her home address were posted online. We call that doxing. Rape and death threats followed. She basically did not leave her house for about 6 months. She has not been able to publish anything in an outlet in India since, and it's been 6 years. She now blessedly writes for the Washington Post in its international opinions bureau, but you know, she can't work in India. It changed who she was and how she thought about herself. And as we sat together and she showed me the video, she explained, even though she knows intellectually, you know, it's not her body, she can't help but think that have been millions of eyes on her naked body. And those people don't know it's not her, right? They think it's her. So, you know, what do we do when individuals and companies and governments are collecting and amassing and sharing our intimate data that we need to figure out who we are, to enjoy human dignity, and to fall in love, right? For the most part in the United States, we woefully underprotect individuals. Not only individual privacy invaders, there are often some small crimes that are misdemeanors, but law enforcement refuses to enforce these laws because they're misdemeanors. They just say, hey, it's not worth the resources. And when it comes to sort of, hey, you could sue an individual for a tort action, it's just not worth it. There isn't a deep pocket to sue, thanks to Section 230 of the Communications Decency Act, which it's been understood to immunize sites from civil liability for information provided by somebody else, so user-generated content. And you know, for companies in the United States, we have a consumer protection model. And so what that generally means is that so long as you have a privacy policy, you don't lie to individuals in those privacy policies, then it's fair game to sell that information. And often when data brokers are selling that information, their biggest client is often law enforcement, state, local, federal law enforcement, and government agencies. And so, you know, we do have a smattering 5 states that have what they call comprehensive privacy laws, but they're effective. They are weak sauce procedural commitments that let companies know that they want to opt out of the sale of their data or the use of their data for cross-contextual targeted advertising, but they're still collecting it, right? And the presumption is that they can, and the presumption is that they can sell unless individuals contact companies. When I surveyed my students the other day and I said, well, how many of you, we live in Virginia with this comprehensive privacy law, how many of you have invoked your rights? And like not a hand went up out of 50 students. And nor have I, right? It's a lot of work and I can't go to each of the thousands of companies that have my data. It's just not feasible for me. So the laws on the books just aren't, they're woefully insufficient because we treat intimate data as a consumer protection matter. We don't impose obligations on companies to be the stewards of that data. We rely and lean in on individuals to protect themselves, and they can't, right? They can in an age of our saturated information everywhere. Sigh, right? If I could see you all, you would be with me and think, oh goodness, where are we now? So at the heart of my book is an argument that we should understand intimate privacy as a moral right, as a fundamental human right, not only that the government owes us, but that companies and individuals do. So crucially, as a civil right. That when we say something is a civil right, what we mean is that it's a right that can't be easily traded away. That companies can't say, oh, it's profits, it's easier, it's more efficient, makes our lives more, administrable and filled with joy. That's just not good enough. That it makes you profits isn't good enough to take away my intimate privacy. You need a really good reason. And individuals, when they're caught invading intimate privacy, the response is often, I was joking, showing off to my friends, right? It's not often for revenge. We misconceive of the problem when we call it non-consent, we call it revenge porn, right? And that's just not good enough. That you were showing off for your friends and you didn't intend to harm someone is simply not a good enough reason to invade someone's intimate privacy. And, when it comes to governments like that, it makes under many state Medicaid laws, social workers are required to ask of poor pregnant women whether they've had miscarriages, prior abortions, experienced domestic abuse, done drugs, and they ask them whether they want to keep their pregnancies. And none of that information is necessary to support someone and ensure a healthy pregnancy, right? We shouldn't be asking those questions. Law should not require it to interrogate a poor pregnant woman in that way, which now we know can be used as the basis of a prosecution if the woman doesn't come back for a further visit. And so calling something a civil right not only ensures it applies to both public and private actors, it not only says that this right is so important that you need a really good reason to take it away. So it helps educate us, right? It sends in a message about what it means, that it's morally significant. But also under US civil rights law, when you say something is a civil right, when you say like education, the ability for the disabled to use public transportation, when you say something is a civil right, what you're saying is that powerful entities that have power over those rights have to act as the stewards of our rights, that they've got responsibilities to be the guardians of those rights. And so what I do in my book is lay out how we might translate those stewardship duties. And often that might mean you can't collect it unless you strictly need it for a product or service, unless that's, in the case of the corporate spies, and that you can't sell it, period. End of story, right? We often sort of sanitize a lot of the trade of our data by calling parties like first-party data collectors and third-party data collectors. And I think we're better off calling third-party data collectors as total scofflaws. They should not have their hands on our intimate data. They shouldn't be able to buy it, or parties that deal with us shouldn't be able to share it with them, which is so often the case. They're sharing it, they're trading it, right? And so that should not be an option. And relying on the work of Woody Hartzog and Neil Richards, in order to make meaningful having stewardship duties, companies need to owe us a duty of loyalty, of confidentiality, and of care. And so, another way we can think of this stewardship duty too is online service providers that enjoy now an immunity from, they get a hall pass from liability, from destructive abuse on their services that they make money off of when we like, click, and share. You know, their business model is online advertising. They so happily spread abuse that garners likes, clicks, and shares. And they have a license to do that under Section 230 of the Decency Act. And we need to reform Section 230. So I've been working, golly, for the past, it's a very unpopular position, at least at the time I started writing about it in 2008. It's become less unpopular over the years. I'm working with folks on the Hill to think about ways that we can keep Section 230, but to reform it to ensure that interactive computer services act as the guardians of our intimate privacy, that they need to earn that immunity with a duty of care. And, you know, so I've worked also, you know, of course, law can't do it all. It is a blunt tool. I've been working with companies over the last 12 years to make inroads in how we can protect intimate privacy. And, you know, we need to bring moral suasion to the table. Like, companies will bring me in, they hear my advice. It's a take it or leave it, right? Law doesn't require them to do anything, right? And it's often only when we give them really bad PR that they actually change their policies. So I think we need to bring the case to protect intimate privacy to companies themselves. And I have a pretty good example of how we've seen that happen. And it's an example from South Korea. So just to preface this by saying I work pretty closely with the South Korean Digital Sex Crime Content Commission. But before, you know, they began this commission in 2018, when any woman or girl went to the bathroom, a public bathroom in South Korea, the assumption was that there was a hidden camera in the bathroom that would stream what was going on in the bathroom to the cloud. And women would bring what they then called molka kits, because that's the name of like a hidden camera TV show, like a jokey TV show. The molka kits would include a screwdriver, silicone, and mask. This was pre-pandemic. So if you dared go into a public bathroom, you'd have to fill in the holes that you see anywhere in the stall. You'd have to break holes. That's why you use the screwdriver, and you'd put on a mask. And a lot of women just wouldn't go to the bathroom. You know, if you were out in public, you figured you had to wait till you got home. And in 2018, there were 5 marches in Seoul. The first march had 25,000 women and their allies. And their signs, both in English and Korean, read, "My life is not your porn." 3 months later, there was a second march. It was 40,000 women and allies, again, with signs, "My life is not your porn." 2 months later after that, so I think it's in March, there were 60,000 people on the streets of Seoul. Again, "My life is not your porn." The fourth march had something like 90,000 people. And the final march, it was freezing. It was December of 2018. There were 125,000 people who took to the streets. Again, "My life is not your porn." It was enough was enough. And the South Korean government and industry responded, creating the Digital Sex Crime Information Commission. They took that name because that's what advocates wanted. They didn't want to call it molka, like hidden camera, as a joke. And we provided advice to the Digital Sex Crime Information Commissioner and urged them to listen to their advocates, much as lawmakers in the United States had listened to us at CCRI to call non-consensual pornography. We were calling it revenge porn, and our argument was it's nothing about revenge. And even if it was, it makes it seem like it's the victim's fault, and there's nothing consensual about it. So, you know, not only like taking the orientation and thinking of victims, but having a whole kind of project approach, which was supporting victims, providing support for them if they lost their jobs, housing support, reinvigorated and enforced then criminal laws and laws that then limited the immunity, it took away the immunity from platforms. And so it's of course, in fits and starts, as in anything, social and cultural attitudes are tough, especially misogyny is universal. And unfortunately, as I've discovered in my work, it's tough to change overnight. But last year there were 5,000 women who reported non-consent, digital sex crime information to the commission, and 70% of them took the commission up on their offer for psychological counseling and support. And the government acted proactively to help get those photos taken down from platforms. And so I'm not giving up on the project that we can't do this, right? That we can't protect intimate privacy. The less intimate data and intimate information and surveillance of intimate life that's in our hands, the less we can mine and use against people's will in ways that they don't expect and want, in AI systems that you're going to talk about over the next, over the course of this conference. And so with that, I know I want to make sure I'm within time. And I just want to thank everyone for having me. For what's so wonderful is that my colleague Ashley is sitting in the audience. So you have 2 UVA law profs here at the conference, and beloved Frank Pasquale also in the audience, my former colleague at the University of Maryland. So it's such a delight also to be on the virtual stage with Ryan Calo, one of my dearest friends. So I just wanted to a note of thanks for having me, and looking forward to Ryan's keynote, Professor Calo's keynote, and for our discussion. So thank you.
Thank you so much, Professor Citron, for the excellent presentation with regard to the importance and also the urgency of protect the rights of privacy. And for now, as we still have a couple of minutes left, I would like to take this very special opportunity to also open the floor for a short Q&A session. So for our on-site participants, if you have any questions for Professor Citron, please just raise your hand. Thank you very much. Okay, is there any questions? Okay, so now for our on-site participants are still forming their questions. Me, myself, I have a question for Professor Citron. So I think it all echo with our on-site participants very much because last year, like as you mentioned about the deep fake technology, last year we also have a famous YouTuber who used this tool to make poems about famous female celebrities and to make a profit out of it. And of course, these people, they are already being brought to the legal punishment. But my question is like regard to deep fake or the AI tool that can be used to harm individuals. Is there a way, like how can we, or under what kind of mechanism can a legal system of a country to punish whoever does that? And if that person is outside the national border? That is my question. Thank you very much.
Maggie, thank you so much for the terrific question. And let me take the second question first, which is like, what do we do when a perpetrator is outside of our jurisdiction? And that is what do they say, the $1 million difficulty, is that so often, perpetrators are either in the United States outside of the state in which the victim lives, or outside of the country. And when a perpetrator is, of course, outside of your country, the long arm of the law will not reach them. You cannot haul them into your courts, nor, even if you could, the expense of it would simply not be worth it. You've got to somehow incentivize or get, in country prosecutors interested. And the theory has to work that they have jurisdiction over the person for targeting a victim outside of the country. So it's perplexing and it's difficult. So Bobby Chesney and I, a colleague at the university, now the dean of University of Texas Law School, and I have written a bunch about deepfakes and have since 2018. And some of the difficulty that we found is that existing law, beyond, and defamation law, I think is perfectly suited for a tort claim for liability for deepfakery, is well suited to address reputation damaging deepfake, especially sex videos, which are, of the 70,000 deepfake sex videos online, 95% of them are deepfake sex videos and 99% of them are women's faces morphed into porn. Right? The great difficulty is there isn't a deep pocket and to sue, and add the immunity, right? So that you can't even ask a site to take it down, right? That is, injunctive relief isn't available because why? The victim of the deepfake didn't create it herself. It's not her copyright. And so you're in this terrible world in which law seemingly has very little to do with your suffering. Something that I've worked on with the Cyber Civil Rights Initiative is thinking about federal criminal law reaching what we call digital forgeries. That would, that is digitally manipulated imagery that causes harm of a kind that we traditionally recognize. But has that gone anywhere? Not quite yet, right? And so the hardest part is its virality, right? And how these deepfake sex videos, especially when, as you noted so well, like you have celebrities who are often, some of the biggest sites like Mr. Deep Sex Fakes or whatever will have thousands and thousands of deepfake sex videos of women. So many of them are celebrities or well-known figures. They are from all over the world. It is because these sites are largely located in the United States, no one can force them to take it down. They're hosted there. And it is infuriating. It is life-changing. It's incredibly damaging. And the hardest part is that because these videos are not hosted in the country in which the victim lives, it's very difficult to bring, as you noted really well in the second part of your question, process to bear.
Okay, thank you so much for the detailed reply. And as we all know, it's a very difficult path to walk on and to move forward. I think that's the very reason why we all gather here, and to highlight and also to strengthen the significance of intimacy, privacy to be seen as a civil and also as a human rights. So due to time constraint, I will have to say that we'll need to close the Q&A session here. And once again, thank you so much, Professor Citron, to share so many valuable experiences with us. And we also look forward to have more discussion with you in later on panel discussion. Thank you so much. Once again, let's thank Professor Citron for the remarkable presentation. And now we will move on to the second keynote speech. For the second presentation, we are honored to have U.S. legal expert Professor Calo to be our speaker. Professor Calo is the Len Powell and Dr. Ray Wen Gittinger Professor at the University of Washington School of Law and the founding co-director of the interdisciplinary UW Tech Policy Lab. His research expertise is in the areas of law and technology, privacy, AI, and robotics. And today, he will be sharing with us Artificial Intelligence, 3 Challenges for Privacy. As Professor Calo is already online, now without further ado, please join me in welcoming our distinguished speaker, Professor Calo. Hi, do we have Professor Calo online?
I'm sorry, can you hear me?
Yes, perfectly and well.
Okay.
But for now, we
can,
sorry, could you please wait for us for a second, since we are sorting out some technical difficulties for the on-site screen. So Professor Calo, please just stay with us for a moment while we try our best to sorting out the difficulties. Thank you so much.
Sure.
Yes, perfect. We can see you now. So now, please, can you share your slides with us? Thank you.
I will. So I just want to say before I do that, I'm about to share my slides so that you can see them. Let's see here. Okay, so are my slides visible to you?
Yes, thank you.
Wonderful. Thank you so much for inviting me to this important international event. It was such a delight to hear from my friend and colleague, Danielle Citron, about her incredibly critical work around sexual and intimate privacy. I can think of few more important challenges right now for our time involving information privacy. So my talk concerns specifically the intersection between artificial intelligence, which is the topic of this conference, and and privacy. And more specifically, my talk concerns specific challenges that artificial intelligence raises for privacy and privacy law that are arguably distinct from prior concerns that permeated the internet or other forms of digital spaces. And so in other words, this is a talk about what's different, what's new, and what's specifically challenging for privacy and privacy law. And while my remarks are mostly grounded in United States domestic law, my understanding is that many of the challenges that I'm going to be discussing with you today also appear in European and in other international and foreign contexts. And so I think there are going to be lessons throughout this talk that could come to inform policymaking outside of the United States as well. Okay, so the first thing I want to say, and I think this is really important as we spend the day together talking about artificial intelligence, it's important to understand that artificial intelligence is not something. It's not some object like a train or even a train system, not like a railway system. Rather, artificial intelligence is best understood as a set of techniques that are aimed at approximating some aspect of human or animal cognition using machines. So what this means is that we're not talking about some object, we're not talking about some set of objects, we're talking about a set of techniques. And the reason that this is important is because there have been many calls to govern or regulate artificial intelligence, and that doesn't seem possible to me in and of itself. That is to say, I don't know that we can look at something and like, artificial intelligence and say we're going to write rules that are specific to artificial intelligence. Now maybe some of my colleagues might disagree with this premise, but that's my understanding, is that artificial intelligence is just an aspirational set of techniques to accomplish something. Now, just because we can't regulate something that's called artificial intelligence doesn't mean that the law or legal institutions don't need to change in light of these techniques becoming so powerful as they are. So let me say that one more time. You can't really regulate AI per se, but we need to change law and legal institutions in order to adapt to the new affordances or capabilities that artificial intelligence lends. So what I'm going to talk about are three different facets, characteristics of artificial intelligence. I'm especially talking about machine learning and often deep learning, but I'll be talking about potentially a range of different kinds of techniques. But what I'm talking about here is three different ways that artificial intelligence change what people do and how they do them. What I'm going to be calling are affordances, which is a term from perceptual psychology, James Gibson, in the 70s. And it just means, what people can do with their environment. What are human capabilities? And so the first challenge that I want to talk about is a challenge around patterns. So much of what artificial intelligence does, that is the reason that we're talking about it constantly, that it's the reason that it's in the news, that's the reason that it's so exciting and powerful, that it can be used in contexts like healthcare or transportation or translation and many other things, is that artificial intelligence is capable of spotting patterns. And it may look as though some of these new applications that create text or a video or generate faces that are not real, it may look like those so-called generative AI is not about spotting patterns, but in many ways it really still is. That is to say, the core of these technologies like ChatGPT that allow a system to answer these complicated questions and create an essay from scratch and do these kinds of things, really it's still leveraging pattern recognition technology. You know, facial recognition feels like it's very, very different from generating a deep fake or generating a face that isn't real. But in many ways, it's leveraging the same kinds of techniques. A lot of this stuff is simply astonishingly good pattern recognition. So why does pattern recognition, the capacity of AI to spot patterns, why is that a challenge for law? Well, what I have noticed in studying artificial intelligence and privacy in recent years is that one of the most threatening and concerning things, and one of the most powerful and beneficial aspects of artificial intelligence, is that it is increasingly able to derive the intimate from the available. And you heard Professor Citron use examples of this already in her own talk, and they're really important ones. But the basic idea is that all of us are shedding information about ourselves online and in person. And oftentimes we're not on a lot of guard, not just because we don't know where the information is going to be ending up, but we sort of can't imagine why it would matter. Why would it matter what you're buying at Target? Why would it matter, you know, what browser you're using? Why would it matter what you tweet? Why would it matter where you go? And so on and so on. These things feel like they're just available to everybody. They're almost public, or if they're not public, they're not too concerning. So the reason that it matters is because what's happening is that artificial intelligence is able to derive things we don't want people to know from the sorts of things we don't think we care that they know. And there is this famous example, which I've done a little bit of digging, and it's possible it's somewhat apocryphal. I mean, meaning maybe it didn't quite happen the way that it's been described, but it's the subject of this article and in the New York Times Magazine and of many other articles that are comparable. And it's a famous example in privacy in which Target, the enormous box store Target, was supposedly able to determine that one of its customers was pregnant before either she herself knew that she was, or at least before her parents knew, and then use that information in order to target coupons to her that were pretty clearly revealing that she was pregnant. And she had never told anybody at Target that she was pregnant. She had not, like, they saw that she was or anything like that, but her shopping patterns apparently allowed the company to infer this status about her unbeknownst to her and unbeknownst to her parents. And that is a very good paradigmatic example of artificial intelligence spotting a pattern and being able to derive something intimate from simply what was available. And so Alicia Solo Niederman, who's an up-and-coming rising star in our world in the United States privacy law, she refers to a whole phenomenon which she calls the inference economy. And this is this idea that not only can companies leverage the information that they gather about people, but increasingly they're able, because of artificial intelligence and similar techniques, to leverage the inferences that are made on the basis of that data. And these inferences can be quite surprising and quite invasive. For example, there was a study out of Microsoft Research a few years ago where researchers were able to determine whether or not women were suffering from whether or not people who had babies were suffering from postpartum depression on the basis of a semantic analysis of their tweets on Twitter, and with a high degree, above 90% reliability. And so when they established from ground truth whether the people had been clinically diagnosed with postpartum depression through their qualitative work, they were able to show this certain pattern of tweeting where the person was not necessarily saying I have postpartum depression or even making references to depression at all, or even sadness, and yet the quality of their engagement online revealed that. So, you know, I'm sorry, this is Alicia Solo-Niederman's article, Information Privacy and the Inference Economy, which I highly recommend to those of you who are interested in this topic. And she makes essentially the point that I'm talking about here. So why does this matter from a privacy perspective? It matters from a privacy law perspective because so many United States and other laws rely on distinctions that are breaking down. So, for example, a distinction between information that is personal information or personally identifiable information and information that is not personal or personally identifiable. And as Paul Ohm at Georgetown has argued in the context of anonymous or pseudonymous data that has been anonymized, increasingly the problem is that people can be re-identified through artificial intelligence and other data analytics techniques, so that there really isn't a very good way to make sure that information stays non-personal. You get enough information and you can infer who a person is. One classic example is that a company like a TikTok or a YouTube or whoever else can actually re-identify that you are the same person viewing videos on the website, even if you don't sign in, because they have done something called fingerprinting your browser, meaning looking at the settings of your browser and determining that it's uniquely you. And then when you go back to the website, they know it's still you. But I think even more importantly for our purposes, United States state laws and federal laws and laws all over the world also have distinctions between information that might be health information or might be sensitive information. And you know, the problem is that information that doesn't feel like it's health information, doesn't feel like it's sensitive information, becomes those things when you apply machine learning to it. Just as I made an example earlier, if you can derive from people's ordinary Twitter interactions, their tweets, that they have postpartum depression, the tweets are not medical information, the tweets are not sensitive information ostensibly, and yet you can derive something that people may not want you to know that is health data, that is sensitive data. So that challenge of being able to derive the intimate from the available is non-trivial and something that the law will have to grapple with, not just statutory law, but also interpretations, for example, of the Fourth Amendment, which is the prohibition against unreasonable searches and seizures, and other places where courts are grappling with the difference between information that might be public or private, personal or non-personal, sensitive or not. Okay. A second challenge that I want to address is the growing tension between privacy and fairness in the context of algorithmic decision-making. The idea being that AI and algorithms are being used to make decisions that are consequential about us. Who's going to get hired or interviewed, who's going to get a loan, who's going to get benefits from the state that they might need, like social welfare benefits. All kinds of things are being, what you see online, all things are being sorted by these algorithms and by AI. And there's a deep concern that that sorting might be unfair. It might be biased against, for example, minorities, people of color, against women, against people who are not mainstream, people who are queer, all kinds of different things, that there might be this deep concern over fairness. And indeed, as the New York Times has shown, it is absolutely disproportionately the most vulnerable minorities among us that are being harmed by many of these applications of AI. So for example, it is no coincidence that the misidentifications of facial recognition that have led to arrests of people who are not actually at the scene have typically been Black men who are already over-targeted by the carceral system. they experience an unfairness that comes of being a combination of being targeted by the police and having facial recognition technology not work so well for them. That is to say, not work as well on Black faces. Although the solution is not simply to make artificial intelligence better at detecting and sorting Black faces, in part because there's also a deep unfairness on where facial recognition is actually deployed, who is getting surveilled. The people that are getting surveilled are often themselves the most vulnerable. And so if the technology works better for surveilling them, it doesn't necessarily count as a win from fairness. But the tension I'm talking about here, and the thing that I think that privacy and privacy law and privacy scholarship will have to grapple with, is the potential that there's a conflict between privacy in terms of not wanting there to be too much information, wanting information to be minimized, wanting to make sure that we only collect the information that we need, wanting to be protective and not promiscuous about information, and the idea of making sure that algorithms and artificial intelligence is fair. This is not a unique insight to me. A lot of people are talking about this. This is from a symposium at Stanford in 2013, Cynthia Dwork and Deirdre Mulligan, who's known to us, all of us well. And it talks about just the way in which sometimes if you're trying to figure out whether an algorithm is going to be fair or not, you need to know a lot. You need a lot of information. You need to be able to track all kinds of things personally and at a system level in order to try to figure out whether or not a system is fair and to make it as fair as possible. But something that I've been thinking about a lot with with an intellectual historian who works with me here at University of Washington, named Maria Angel, is that, today, when we talk about algorithmic discrimination and we talk about unfairness in algorithms, we often do so under the big umbrella that is privacy law and privacy law scholarship. Many of the conversations about algorithmic fairness in the law take place at venues like Privacy Law Scholars Conference, where there's privacy law scholars. And so one of the things that we think it's important, that Maria Angel and I think is so important to do, is to really disentangle what are the values and goals of privacy law. What is privacy really about? As opposed to anti-discrimination or some of the other values, because those values might come into conflict. It's also a point that David Posen has made, who is a law professor at Columbia, where he talks about privacy trade-offs, the idea that sometimes there are values within privacy that need to be traded off against other values. But what I want you to understand as the challenge is that there may be ways in which wanting to limit access to information, which is a valuable goal, wanting to minimize data to only what you need, wanting to make sure that people retain control over their data and that not too much data is collected, that may come into conflict with other important values that we really care about, like making sure that vulnerable populations are not being treated unfairly by algorithms and artificial intelligence. Now, you may be thinking, and I certainly agree, and indeed Professor Citron and I have written about this, as has your other distinguished, frankly, all of your distinguished keynotes here have written about this, which is that maybe we shouldn't be making consequential decisions about people using artificial intelligence and algorithms until those systems can be shown to be reliable and fair, and maybe not even then, because maybe even then it's dehumanizing to sort people and make consequential, important decisions about their lives using machines. Well, I'm very sympathetic to that. But what I'll say is that it's being done. And sometimes companies and governments who are using these systems to sort people will say, we can't tell you precisely what we're doing, and we can't gather the information that you want to test whether these systems are fair because privacy. So the challenge to me, a second challenge of artificial intelligence, at least as it's deployed today, is how do you reconcile something like the need for data minimization and privacy with this concern over things like fairness. And so this is this paper that Maria and I have written together. It's coming out in Columbia Law Review later in the year. And it just talks about the need for us to think hard about what makes privacy a unique value, and to situate privacy in a broader set of information-based harms. Okay. So the third and final challenge that I want to talk about, I actually have one more, but the third, contemporary challenge that I've been thinking a lot about that artificial intelligence poses is less to privacy per se, but more to sort of data protection and security. And that's this idea of tricking. So what do I mean by tricking? Well, the idea of tricking is that artificial intelligence is using sensory data. It's using information about the world. It's using its capacity to process information in order to do consequential things, including driving a car or, not just making decisions about people's credit or whether they're hired or some of the other things we talked about, but literally to drive a vehicle on the street. And it can work very, very well. And there's some speculation, I don't know how well evidenced it is, that driverless cars, as one example, cars that drive themselves, that they will one day be much safer than people. And the idea is that the combination of having more sensors, being able to see better around the car, having faster response times, and being just as good as identifying problems will mean that they will reduce human error. And at least in the United States, human error is a really, almost all accidents, a huge percentage of fatal accidents in the United States involve at least one element of human error. So the idea is that these systems are going to be better than people. But what has been shown, in fact, for example, by security research at Tencent, as one example, is that these AI systems, as reliable as they may be in ideal conditions, can be misled, they can be tricked. So what they show in this particular study that's written up by a security journalist, Evan Ackerman, is by putting little hard to detect by people stickers in the road, they can cause a Tesla, the electric vehicle that has some self-driving capability, autopilot capability, to swerve into the wrong lane. In other words, by understanding the detectors and classifiers, the artificial intelligence on board the Tesla, these researchers were able to trick it into going into the wrong lane, which of course is very, very scary and dangerous. Prior to that, my colleagues at the University of Washington in computer science showed that by perturbing, changing the pixels and changing a little bit a stop sign, that you could actually cause a driverless car to perceive a stop sign as a speed sign. Again, very dangerous. So rather than coming to a stop, having recognized that there is a stop there, that the car would perceive that it was actually a speed sign. And so we, based on this kind of work, which is known under the general label of adversarial machine learning, where you try to understand an AI model well enough to trick it into doing something it's not supposed to do, we began to think about, what does that mean from the perspective of security and the perspective of anti-hacking laws against compromising security of systems. And, my colleagues and I, some of whom are in computer science, some of whom are in law, and we're the authors of this paper, started to talk about how the law should think about tricking as opposed to hacking. So in United States law and international law, the hacking that's prohibited, prohibited hacking, involves bypassing a security protocol, breaking into a computer system in order to exfiltrate, take away data, mess around with data, compromise the integrity of data, or do something else that you're not supposed to do. But it's a breaking in. You're hacking into the system. And the way that, for example, the Computer Fraud and Abuse Act in the United States talks about it is that you are exceeding authorization or engage in unauthorized access to a protected computer. Again, the idea is that you're breaking into it, and that's also how international law and standards look, okay? And so these techniques of presenting a driverless car with a fake stop sign or stickers in order to manipulate it, and many, many other techniques, for example, when Microsoft released its Tay chatbot on Twitter and people got the system to train the system in order to say things that were racist and anti-Semitic so that Microsoft had to shut Tay chatbot down. Again, they weren't breaking into Microsoft. They weren't breaking into the system. They were just using what they understood about the chatbot to train it to say bad things. They were poisoning its training set. And many other examples as well. Researchers at Berkeley showed that you can play these tones and that the Amazon Alexa smart speaker will order things online for you that you didn't want to order and that you didn't hear as ordering. In other words, playing tones that the system interprets as a command to order something, even though no human heard it that way, right? All of this is this adversarial machine learning. Well, none of it is breaking into a computer system per se. None of it is hacking exactly. And so that means that if you're going to capture it with the law, you're going to have to use some law that is not really suited to that. So for example, if you want to catch people who are trying to cause Teslas to crash or any driverless car not to stop at a stop sign, you'll have to find some other law that might get at what they're doing. And if they do it at some big scale where they're doing it to as many possible cars at once, then you're going to be hard pressed to get to bring the law to bear on the problem. But in any event, you're not using the standard tools we think of in security. I think a more fundamental point, though, an even more important point, has to do with the idea of setting expectations around security. So today in the United States, and this is very closely related, of course, to privacy, today in the United States, if you are a company that uses people's data and you put products and services out into the world, you have an obligation to make sure that it's secure enough, that it's not easy for hackers to get into it. If you put something out there and it's really, really easy to break into it and get people's information, their banking information, their personal information, their whatever, their address, phone number, the copies of their communications, all these different things. If you build a system that's not adequately secure, then you can get in trouble. You can get in trouble. How can you get in trouble? For example, our Federal Trade Commission, which is the chief consumer privacy watchdog for in the United States, might go after you under its authority to pursue unfair and deceptive practices by pointing out that by putting a service or product into the world that's not secure enough, you are being unfair to your consumer. But the problem, of course, is that standard, again, is thinking about hackers breaking into your system because you don't have adequate security. It is not necessarily thinking about the fact that you have used artificial intelligence that is too easy to trick. So if you put a product out into the world like a driverless car, where if it's tricked in a predictable way, people get hurt, well, then we can use product liability. the idea that you can sue someone because you got physically hurt or your property was hurt by a bad design of a product, an unsafe design. But if instead what's happening is that people are not getting a loan online, or they're not getting goods or services, or they're seeing content that's manipulated, or all kinds of other bad things, they're not getting a job that they wanted, or someone else is getting that job who doesn't deserve it, because those people are tricking these systems, well, that's not going to necessarily be covered by products liability. And so one of the things that we claim in our paper together, we computer scientists and law folks, is that we need to really be thinking hard about what security looks like, what adequacy of security looks like in a world where computers can not only be broken into, but they can be fooled. However, you can go too far. So one thing you might say to yourself is, well, let's just make it so that if you fool a system, if you trick a system, that's hacking. And so all these systems have to be resilient against people tricking them. And then if you do trick them, you're in trouble. Under the Computer Fraud and Abuse Act, if you engage in unauthorized access of a protected computer that's a government computer, that is, I think, automatically a misdemeanor. I'd have to triple check that. But I mean, if it's a government computer, there is a certain assumption that you're up to no good under the Computer Fraud and Abuse Act. And so the hypothetical we think about is, well, what if there's a person who is walking around the streets of London, walking around the streets of New York, and there are these government cameras out there that are engaging in surveillance, and they have facial recognition capability. But you feel like that's a violation of your civil liberties. And so you put on the special makeup that tricks the system into not being able to recognize you. So you have a protected government computer, which is this camera with AI, that is serving a government function. And you, in order to feel like you're not constantly being surveilled, and in order to resist that kinds of surveillance, are wearing makeup that tricks the system. Have you suddenly hacked into the system? Are you suddenly guilty of a misdemeanor or a felony under federal law? And so it's not an easy thing. It's not an easy kind of thing to answer. All right. So what I'm going to do is I'm going to stop sharing my slides right now and come back to you in person. Hold on a second. There we go. And just say a couple more words by way of conclusion. So what I've said to you so far is that there is this concern that artificial intelligence is going to change human capabilities and affordances in ways that poses challenge for law and legal institutions around privacy and security. And the first example was that pattern recognition allows AI to derive the intimate from the available, and that causes a breakdown in standard statutory distinctions that such as non-personal versus personal, or sensitive versus non-sensitive, or health versus not, that we've been accustomed to, and that those need to be revisited, among other things. A second example was that there's a tension between wanting to be private and minimize the amount of data available in systems, and making sure that those systems, which are being used in consequential ways, are fair. And the requirement there is for privacy scholars and policymakers to make sure that they can understand and appreciate the distinction between what privacy protects and what something like anti-discrimination law protects, and making sure that those are balanced appropriately, and that systems are designed that are capable of delivering both. And then finally, we talked about how increasingly artificial intelligence systems can not only be hacked into in the standard way of breaking in and doing something wrong, but they can be fooled, they can be tricked. They're so smart that they can actually be fooled by other people. The thing I want to leave you with now, in addition to these three challenges that I think law in the United States and elsewhere have to address, is the prospect that we're all thinking about with these new chat engines, right? So the last thing, I think this is going to be a deep challenge that we haven't even begun to think about enough. Although people like Professor Pasquale and others here have talked about it already in the literature, is the idea that these systems are going to be feeling more and more to us like they're people, like they're social entities. They're going to be talking to us not like a search engine where you type in, you know, a search result in a field and then search engine gives you a bunch of links, but an actual conversation with something that feels like an entity to you. And what's, I think, challenging about that is that, you know, the companies and governments that are behind this artificial intelligence that creates an interface that feels like it's a person, that it's social, they're going to be able to use all the same ways that people use in order to get more information out of others. So one of the things I really worry about is as we begin to have interfaces that feel like you're having a conversation with a person, that will have too much trust in that person, that person will be able to get us to divulge things about ourselves in conversation that we might want to. And so I'm very worried about that. And I'm also worried about a world in which all of the interfaces that we encounter feel social to us. And hence we never feel like we're surfing the internet or using any kinds of communications technologies alone. So I know that I'm out of time, and I really appreciated this opportunity to address you today. And I hope we can talk about all these different themes. And I look forward to the rest of the conversation. So thank you very much.
Thank you very much, Professor Calo, for the wonderful and also informative presentation, and also for illustrating and analyzing and also summarizing the challenges that we might face brought by the artificial intelligence. And as we have a few minutes left, I think we can open the floor for one question. If there is any questions for Professor Calo, please just raise your hand. Thank you very much. Okay, so for now, yes, Professor Jen. It's okay. Yeah, okay. The time is yours.
Okay. Thank you. It's a wonderful talk and very critical issues. And based on that, I also thought that I also worried that, you know, currently we also have those robotic, the human, will make looks so much like a real human. So that's another concern that for me. Because one day you might interact with someone, maybe even face in face, and you don't know it's a real person or it's a machine. Yeah. So that really worries me. So what do you think? Do you think there should be a law also government AI that the technology development should not achieve a status that is too much like a human? Do you think that should be another consideration? That's okay. Thank you.
Yeah.
That's
So first of all, I would say that that Frank Pasquale is very much subject matter expert about this, and since he's actually physically there, I hope you get to have a conversation with him because he's very wise. The kinds of I worry about two kinds of things. Okay, the first thing I worry about is that because all of the technology that we interact with, the search engines, the smart speakers in our houses, our cars, our phones, will feel like we're having a conversation with a person that will never feel alone. We'll never feel alone. We'll always feel like there's something social in our environment, and we won't have opportunities for solitude. So I worry about that. But then second, I worry about the fact that because we are hardwired to react to anthropomorphic technology, such as AI and robotics, as though it were really a person, right? That those systems will be able to use all the same techniques that people use in order to get us to talk about ourselves and divulge secrets about ourselves, right? So I worry about robots and AI that are asking personal questions or interrogating or everything else, because the social science is so clear that people react to anthropomorphic and social machines as though they were really people. And so I've written a number of things about this. Frank has written about this, and I think it's a very thing. So what do we do about that? Do we require robots to tell us that they're robots? Do we ban this technology? Do we place limits on it? That's a live debate that's happening right now in the scholarship and in policy. It's a great question.
Thank you very much, Professor Calo, and also thank you, Professor Jam, to putting forward this very worth-thinking questions. And due to time constraints, I think we will close the session here. And once again, thank you so much, Professor Calo, for the inspiring presentation and sharing. Let's put our hands together to thank Professor Calo again. And we look forward to having you back in the panel discussion later. Thank you so much. Okay, so it's for the morning keynote speeches. I think it's truly a valuable opportunity for us to learn about the global trend and also the current development of AI governance from our international speakers today. And for now, ladies and gentlemen, we will have a 10-minute break. And later, we will invite our two speakers, Professor Citron and Professor Calo, to have more in-depth discussions with our domestic scholars in the field of smart medical research and legal systems. So now, ladies and gentlemen, please be back by 11:20. Please be back at 11:20. Thank you very much. Ladies and gentlemen, the symposium will begin in 3 minutes, so please kindly take your seats as soon as possible. Thank you very much. Ladies and gentlemen, the symposium will begin in 1 minute. Please kindly take your seats as soon as possible. Thank you very much. Distinguished guests, on-site and online participants, welcome back to the morning session. We will now move on to the panel discussion. In the panel discussion, we will invite domestic experts and scholars to exchange their insights and ideas on the characteristics of medical data and data use limitations in Taiwan's medical field, as well as the potential issues of AI data governance. At the same time, we will also invite the two speakers in the morning session, Professor Danielle Citron and Professor Calo, to share the development strategies and practices of AI data governance in the U.S. under the data regulation in and industry trends. And first, let's invite the moderator, Professor Jen Yongzhen Xu, Vice Chair of AI Center of Excellence, onto the stage. Please welcome Professor Xu. At the same time, I would also like to invite Professor Citron and Professor Calo to join us in the meeting room. Good to have you back. And moving on, I would like to invite 3 of our on-site panelists from Taiwan onto the stage. Let's welcome Professor Pau-Choo of Electrical Engineering at National Cheng-Kung University. Professor Albert C. Yang of Brand Science at National Yangming Jiaotong University. And Professor Chuan-Feng Wu, Director of Information Law Center, Institutum Jurisprudentiae Academia Sinica. Welcome. Okay, we welcome all the on-site and online panelists to join us on the stage and virtually. First of all, I would like to invite our panelists and also Professor Xu on the stage to turn on your microphone. Thank you very much. Okay, so in this session, we will focus on medical data governance through talks and exchanges in the fields of research and regulation. We aim to discuss how ethics and legal spirit can be included in data governance issues in the medical field. And now I will hand the floor to the moderator, Professor Xu. Professor, the floor is yours.
Okay, thank you. Thank you for all for coming to this panel. And we are very honored to have a diverse panel of medical, technical, and legal experts with us today. Because of the limited time, we are going to go through like quick fire rounds. And in particular, I would like each of you to take 1 minute to introduce yourself. And then the second round will be 2 minutes each to describe a particular challenge facing medical AI governance that from your specific perspective. And then the third round, talking about a short-term action that we can take and maybe a longer-term solution. And finally, we would like to conclude for the panel, okay? So without further ado, how about let's get started with our experts in the, far away. And Professor Citron, get started with 1 minute self-intro.
I'm Danielle Citron. I'm a law professor at UVA Law School and the vice president of the Cyber Civil Rights Initiative. And my work focuses on intimate privacy. So, of course, the privacy of our health, our medical conditions is one that naturally I think needs special protection, and we woefully underprotected in the United States. HIPAA does quite little for us. So I hope that satisfies as an intro.
Okay, thank you. And Professor Calo?
Sure. I am a law professor at the University of Washington School of Law. I am also on the faculty of the Information School. I don't teach privacy, I teach torts and administrative law, but I write about privacy and including sometimes health-related issues. And I'm excited to be here. Thanks.
Okay, thank you. And our local experts from my left hand side, Professor Pau-Choo Chung.
Hi, everyone. I'm Pau-Choo Chung, also called Alice. I'm from the Department of Electrical Engineering. My research working on the machine learning and also especially for image analysis. Currently, I'm working on pathology image analysis. So that is a huge large of the data. So we often have to meet with the doctors from the hospital, so we need the data from them. So we face a lot of some of the situation and also challenges to ask the data and also to use the data. Thank you. So I would like to share to work with you or to see if we have some of the solution to put this forward. Thank you.
Okay, thank you. Next, Professor and Dr. Yang.
Yeah, thanks, Professor Xi. My name is Dr. Albert Yang, and I'm a physician specialized in psychiatry, which is also one of the medical field that concerns the most about the patients, the confidentiality and privacy. And I'm also the professor in the Institute of Brain Science in National Yangming Jiaotong University. And my research is focusing on identifying the brain markers for diagnosing mental illness and also predict the clinical outcomes. So that also involves lots of AI technology. So it's very exciting and my honor to be here. Thank you.
Okay, finally, Professor Wu.
Hi, my name is Chuan-Feng Wu. I'm now the Associate Research Professor in the Institute of Jurisprudence, Academia Sinica, and also the Director of the Information Law Center. And my research field includes the public health law, healthcare distributive justice, and the right to health. And recently, I also have some researches focused on the use and the process of healthcare data, especially the application of the National Health Insurance Database. Yeah.
Okay, yeah. So, let's get started with, for each expert to highlight one particular challenge in medical AI governance. In particular, feel free to double down on others' point or go against the other expert, okay? So let's start with Professor Citron.
I have a feeling you can see my wonderful cat, Patsy. Okay, yeah.
A very cute tail.
even though it's quite late here, she's so spunky and up doing her thing. Okay, so the challenge I think is, and I'm going to build a little bit. I don't want to steal your thunder, Ryan, but to build on your brilliance, to say that, and I use this amazing line of Ryan's in my book, which is, from the ordinary, right? From the everyday, the intimate. You said it in the reverse, but yes, that's indeed so profoundly true. And so that's of course true of medical conditions, of whether it's you've type 1 diabetes, cancer, whatever the condition may be. And because we so woefully underprotect even the most sensitive information gathered by, let's say, health apps, fitness bands, our browsing and our reading, forget inferences. Our challenge is not only the direct collection of really sensitive information that regards our medical conditions, but then of course amassing the ordinary to infer the inferent, to infer the most intimate. It is yet a challenge upon a challenge.
Okay, thank you. Professor Calo?
Yeah, I mean, first of all, I agree with that, of course. What I would say is that, one really interesting challenge around health is that there are dramatically different norms and expectations about talking about one's health. Okay, so you might have some set of people who are very comfortable talking about their mental health challenges, very comfortable talking about their different kinds of challenges, and not appreciate that in doing so, that those kinds of public statements might be then used against them to increase their insurance or to deny them opportunities, right? So as mores change, as normative expectations change around health, and younger people maybe, or all of us, are more comfortable talking in a public way about the challenges, we have to make sure that the laws catch up and prohibit that secondary use of our own information. It's much more about making sure there's substantive limits about how our health information be used against us as norms change about self-disclosure. So that's the other thing, in addition to Danielle's wise remarks, which I associate myself with.
Okay, thank you. And Professor Zhang?
Hello. I'm from the user point of view to talk about the challenges I face. In order to do the AI, we need to get the data from the hospital, but we need to go to the IRB. Yeah, that's normal and that's easy. But you would like to have the data for open or sharing. That is very challenging. I have tried the IRB. It passed and allowed us to do the research. And then I changed the IRB saying that we would like the data. Of course, the data we usually, because I'm doing on image analysis, so it's easy to have the, the privacy or personal information removed because it's only an image. So as long as you remove the labeling, the tag, or the person's name, then actually it's just an image. But when I said I would like to use the image for the research, and after that I will use that image for our education, for example, open for all of my classmates or students, or for the future, then I resubmit the IRB. Then they say, oh no, oh no. So I think one of the challenges currently now in Taiwan is how we can let the hospital or the person who have the more comfortable to have the data more openly for our education. So now if I do the education, what can I do? I just get some of the open data from the internet, and then so our class has to use those kind of data, but I cannot give it to the students. But for my graduate students, it's okay because for the research. So one of the issues I think we need to more to encourage the hospital to be more open. And I think one of the maybe one of the issue is we use the same law or restriction for all kinds of data, because we know that the medical data actually they have different level of the sensitive of the privacy. Some are more sensitive. For example, if it is your health record, then you record your status, your progress. So it's easy from this progress to identify who is this and what is this. But you can see in the internet, some of the images, just appear an image. I think it's very hard to identify a person just from an image. But in our law, it's medical data. They are all the medical data. So they use the same, probably some of the regulation, and there are some of the concern about release of the data. So I think maybe that's the reason. So it's very hard for us to say that is. And I found that another way is different hospital, they have the different mindset. So I found that because I work with the different hospital, so some of the hospital, their mindset is relatively open. So if I told them that, oh, I can use that for my students because I make sure that I remove all the labeling or everything, they say they can agree. They can agree. But some of the hospitals are not. Do not agree. So you think maybe we should have a more high view from governmental view to specify different level of this privacy and give a different the freedom or force the hospital to give us the freedom to the data. Otherwise, they kind of protect the data very well. That's my view.
Okay,
Thank
you.
you.
So we can sense the tension between data provider and data user, right? Okay, so Dr. Yang?
Yeah, that's interesting. So I can provide my point from the clinician point of view. So as a data provider, I think the biggest challenge is facing medical data governance is that how do we make sure that we can make good use of the data? And that can be explained in several ways. For example, as a medical practitioner, we always want to help patients to solve their sufferings. And then we will try to identify technologies and treatment that can solve the problem. And that involves the clinical trials. So we will collect data based on our research question. So initially, I think the first level is that we really need a good use of data by asking a good question. That would be the first level. And with this question, then we need to collect the data from the patient. But we know that with more and more data we collected, that comes with the privacy issues. So I can share my experience that, for example, I'm collecting the brain imaging from my patients. And we also collected many demographic and clinical variables. And when even the data has been de-identified and delinked, I can still see those variables and images and still feel that I saw those patients. So, yeah, so I think that the second level is that we really need to make sure there's a good intention to use this data. So for example, I have this, for example, from my career, I think that there are two databases I think there's a good example. One is the PhysioNet in the United States that was established by the Harvard professors, Dr. Eric Goldberger and Dr. Roger Mark in over 20 years ago. So at that time, there's no AI and there's no the fancy, or there's no regulations for the public database, but they already published the ECG or physiological data on the internet, and they try their best to protect the patient privacy to do this. And I think that's very important because they have good intention. And they try to build the trust between the patient and the researchers. So I think that's important that we need to make sure how do we make the good use of data. I'm not a law expert, but I think that's maybe one aspect that law can help us to define that. Thank you.
Okay, thank you. And finally, let's hear from the legal expert. Yeah.
Thank you. And because the topic the organizer of the conference gave me is about the healthcare governance in Taiwan, so I will focus more on that. And I think the first challenge that Taiwan faces is that actually we don't have any specific law to govern the process and the use of the healthcare data. Yeah, so even though we have the basic laws such as the Personal Data Protection Act, but the problem is that the healthcare data is quite different from other data. So there should be some specific law to regulate that. And as we all know that the Constitutional Court actually make a very important decisions this year related to the use of the National Health Insurance Database. And the Constitutional Court argued that in Taiwan, we don't have any specific law regarding the health data governance, including the procedure for the use, organization, deletion, termination, and the withdrawal of the information in the healthcare database. So I think it's the first challenge we need to face. And the second one is that we don't have the independent monitoring mechanism. So the problem is that, as Professor Calo has mentioned, the norms or the regulation should be different from the traditional one because the development of the technologies. But actually the government or the society still didn't recognize the unprecedented risk imposed by the systematic collection and the process of big health data. So I think that's the second challenge we face. And the third one, I think, as Professor Calo also mentioned in one of his cases related to the re-identification risk. But the problem in Taiwan is that we don't have clear definition of re-identification. So it caused lots of problems for the researchers to figure out how to de-identify the health data. So I mean that we have lots of legal terms like the de-identification, pseudonymization, anonymization, or delink, but they have different meaning of that. And sometimes the government orders and the court's decisions or the laws are conflicting to each other. And the situation becomes much worse because now we use lots of unstructured data. But the definition of de-identification is actually developed in Taiwan based upon the structured data. Yeah. So when we try to use the EHR or sounds like the medical images, we don't have any standards to de-identify those data. So I think that's the problem we face right now. And the last one, I think the problem is that in Taiwan is that, the challenge in Taiwan is that we have some kind of mixed conception between data security and privacy protection. As Professor Citron has mentioned, there are lots of, the context of the privacy is very complicated, and including not only privacy as security, but also privacy as autonomy related to dignity and human esteem. So in Taiwan, I think sometimes we focus too much on data security, and we ignore individuals' privacy rights or other rights. So like the Constitutional Court mentioned that the right to opt out is ignored in Taiwan system. The other thing is that when we focus too much on data security, other rights, like the right to data portability, is also missed in Taiwan's legal system. Yeah. Thank you.
Okay, thank you for highlighting the complexity and nuances of the entire data cycle. And as people can see, this is not something that can be solved with a simple solution. But we would like to hear from the experts about what would be some easy thing that we may do right away, or something that can be, planned a little bit farther down the road. Okay, Professor Citron, addressing your own challenge or any other challenges from the other panelists will be fine. Yeah, thank you.
Thanks so much. And I have to scoot after I make my remark. So, and thank you for having me. I think one thing that we should think about is access. Mm-hmm. For electronic health records in the United States, it's almost everybody in the chain. The idea is that, of course, everyone has access to, or that is everyone for when it comes to treatment and insurance, that no matter the doctor, no matter the nurse, no matter the hospital, have access to our medical records. And in an age that we now live in, without Roe versus Wade, where the right to abortion isn't constitutionally guaranteed, my worry is that we might need to rethink some of this seamless access, because doctors in states where abortion is criminalized will be seeing records of citizens who have gone to other states to have abortions. And I think so small intervention, but with a big impact, is to enable women to have reproductive autonomy and to travel in the United States. To make that meaningful, we're going to have to, in some sense, limit some of the access to medical records.
Okay.
Thank you so much. I so appreciate everyone for having me. And now, if I don't go to sleep, I feel like my eyes are shutting with you. But it's been amazing to see everyone.
Yeah.
So thank you so much.
And
appreciate
thank you.
All of you.
And we do wish to see you in Taiwan at some point. Okay.
Yes.
Yeah. Okay.
Same. And Virginia too. Just saying. Okay.
Yeah. Okay. Bye-bye.
Okay.
Thank you.
Bye.
Okay. Okay. Let's move on to Professor Calo.
Sure. I mean, so again, I agree with my colleagues that I've heard. And I would say that this is building on my earlier remarks, but I think that we need to have not just limitations on distribution and access to data, but in some cases, we need to have limits on use. I think there's an assumption that once you get your hands on the data, you can do whatever you want with it and only the right people should have it. But I think there needs to be some, and so one of the things I would think about as a model is something called GINA in the United States, which is the Genetic Information Non-Discrimination Act. And what it does is it protects individuals against discrimination based on genetic information. So the idea there is that, at least with respect to genetic information, even if somebody gets a hold of it, they can't use it to discriminate against you. And I think we need more laws like that. It doesn't mean we don't need privacy laws, we do, but an additional stopgap is let's say that there's certain lines you can't cross, there's certain things you just can't do with this highly relevant information.
So are you suggesting that instead of going for a final complete solution, some specific laws can be enacted first? Is that the idea?
Well, that's a great follow-up question. So what I would say is that each jurisdiction has to decide for itself. But if you look at the United States privacy system, right, our privacy laws tend to be sector and activity specific. And unless you're like a child on the internet, you don't have real privacy protections. And even if you're a kid, you don't. Health data is governed by HIPAA, genetic data by GINA, biometric by some state law in Illinois, and so on. So we're very much an activity sector specific kind of organization. And so I don't see the prospect of a omnibus, as much as I would like to see a big, huge omnibus privacy law. It doesn't seem plausible. But I think that the laws that we pass need to think about, even if you have the data, are there things that you shouldn't do with it?
Okay, thank you. Yeah, Professor Zhang.
From my perspective, I think As I mentioned, actually, we mentioned about the medical data. Actually, it's a broad range of the different sensitivity of the data. So to me, I think because we know that now is in the competition for the AI techniques, and to benefit and to promote and to improve the diagnosis or the assistance to the doctors to help us to promote our healthcare. So actually, to the AI development is a good direction, especially for the healthcare issues. So I think we should encourage that. But since the data has different sensitivities, so to me, I think the immediate action we can do is we should probably get together and to identify. Even for our government, we have collect some of the data, so huge data in the high performance computer center. And but the use of the data are under the same regulation, that is medical data. So my perspective is actually we should probably should define if it is certain kind of data, this is security is privacy is very minimum, and how we can use that, and so we can define the different level of the security of the data, and that to give the different restriction for this, so that we can release the technical area and the education, the research, so they can freely use at least some of the less sensitive data. So they can easily and more popular. Currently, why we cannot have the data open or more popular being used to release to other group beyond the IRB? When I applied an IRB, I specify who will use the data. And once I have new students, I upgrade the IRB because I add new students coming. So that gives some of the restriction. But I know it is necessary if you think about some of the very sensitive data, because it's very highly, highly sensitive to the patient. But it is just a very minimum, like EEG signal, ECG signal. Then I don't think we need such a high level of the restriction. We should more encouragingly for the students, for the researcher to use those kind of the data. So if we can have a certain level of the discrimination or the differentiation and set up the different rule, and then so that all the students or the researchers they can more freely to use the data to promote the AI technique. And then once it goes to more sensitive data, then we can give the high regulation. Then I will agree. So in the more short-term relation to have more, to have opened up our data, I think that is one of the direction maybe we can try to see to do. And in the long run, there's another issue, because the data has been differentiated as a retrospective data or prospective data. Prospective data is easily, because for every data, the patient has to be there, has to sign the consent, informed consent. But the retrospective data, according to the IRB and the law, there's no patient consent required. And because there's a huge person maybe involved, and they has been passed before. They have been, anyway, you cannot contact them very easily. So for those respected data, that now IRB is allowed to use. But for open this respected data, there still, there still seems we still need a consent. And how to get the consent is another issue. I try to fight with the hospital for many times. Whether we can use the email to contact them, and they said there's a law protect the patient's data. For example, if the data, the patient's data, you collect, the hospital collect the patient's personal information, you can use the personal information, the data, only for his or her healthcare issue. So you cannot use it for advertisement or other issues. So sometimes it's more sensitive to the patient. They would, if you contact them too frequently, they would, kind of say, sue, or how to say, pursue to to the hospital and saying that why there's someone contact me about that. So they are kind of the hospital, the personnel, they kind of protect themselves. They are kind of a little bit frightened about doing things more aggressive. But if we have the law to protect them, to help them, then they can do more openly the aggressive. They will not be, you know, they are kind of afraid of the patient to sue them, so they are afraid. So that is my perspective. Only if that break, then we can have a whole country more openly use the data, more freely to use the data. But we need to have consensus between the hospital and our government and even our, you know, some of the group, they are having a high privacy consent. We need to communicate with them and to talk to them and to work with them that this data is less sensitive, this is more sensitive. Don't use a same standard for all of the data. That's my perspective.
Okay,
yeah,
thank you. And from the medical perspective?
Okay. Yeah, I would like to echo the remarks from our panelists and also my earlier remark. And I think still the one action item we need to do now is to try to make sure to make good use of the data. That includes the data quality and also the good question and also the ensure the patient's privacy. And I think the most important one is really need to make sure we do have the good intention to use the data, because that would build the trust between the patient and the researchers. I would like to provide another example here because probably anyone knows there's a Framingham studies in the United States that conducted since 1948. It has been 3 generations for this study. The study site is in a small town in Massachusetts, it's Framingham. And the participant is around like 5,000 to 10,000. But surprisingly, this study is very successful because they answer lots of the questions to the medical field. And also they build a very good trust between the people in the Framingham and also researchers. So there's a report saying that in the Framingham study, when they collected 3 generations of the genetic data, and they asked the participant if they wished they allowed to use the data for another research purpose. Almost every one of them agreed to that to that consent. So I think that's important one, because if we do have the trust between the patient and researcher with a good use of data, then we can, in the long run, we can solve the issue of the consent, because because for the consent for another purpose, we also don't want to lose patient. That would affect our research quality. But with the trust, I think even with the dynamic consent or other mechanism we are doing now in Taiwan, I think that would be not a problem. Yeah, thank you.
Okay, thank you. Yeah, Professor Wu.
In my perspective, I think that the amendment of the law and the harmonization of the law is an important issue. But the other thing is that we should be very careful to establish, and we need to establish the independent data governance or the risk of privacy assessment very quickly, because I agree with Professor Chung that we should not use the same standard for all data. But the problem is who can decide which data use is sensitive, which is not. And we don't have any standard for that, and we don't have any independent assessment mechanism for that. Especially the government still use the traditional conception of privacy or of the data governance to deal with this kind of issue. So in Taiwan, the problem is that we kind of think the data or the variable which is sensitive, which is always be sensitive, but some data which is not sensitive, which will be always not sensitive. But actually in big data era, when we try to use different data and we have the volume of the variables or the amount of the variables or how we use that and the capability of the users, we are all influence the sensitivity of the data. But actually in Taiwan, we don't have any mechanism to deal with that. Even though IRB might be some mechanism to review that. But the problem is that information technology scholars or experts are not included in that. So the problem is that it's kind of, we kind of work in the fog. We don't know the direction. So I think that's the short term we need to resolve this problem. But in the long term, as Professor Yang just mentioned, I think trust is a very important issue. And we need to establish the social trust in data sharing. But I think the trust is not upside down process. It should be bottom up process. So we need to respect autonomy. We need to establish the due process, and we do need to guarantee the transparency. So we don't want privacy protectionism, which is overly restrictive the use of the data. But we also don't want that the data sharing is kind of obligation of individuals. The problem is that solidarity should be established bottom up. So we share when society trusts, and we retain the privacy rights and interests in context of trust. So I think in the long term, we should include people or include citizens in a participatory data governance approach for data use. And also, we should establish a fair due process for the use of the medical data. And I think it's important to establish the social trust. And it's not a good way to use the law, use something, say, you are required or something like you need to donate the data. I think it's not a right way to go that direction. Yeah,
okay, thank you. Yeah, so we are running out of time, but I do want to steal a little bit of your time, maybe for one question from the audience or anyone. Before we conclude, all the experts should prepare a simple 1 or 2 sentence conclusion. Okay, but I do want to follow up with one question. A lot of you have talked about maybe not all data are equal, and the data can be sensitive or not depending on the particular context and particular usage situation. And Professor Calo mentioned the fact that it's very difficult to regulate distribution or secondary use. And even so with technology, it's very difficult to see that even though the original intent was good, secondary use may become malice, right? Or the data may be massaged due to technology that they become sensitive, okay? So I don't know if any one of you may want to jump to the question of, is there a possible approach to decide the sensitivity or what would be the right level of regulation for any type of data, okay? Professor Calo, you want to grab the time?
Oh, sure. Well, I mean, so I do need to hop off in a moment because I haven't eaten tonight and I need to go get some dinner. But I've had an absolutely wonderful time, and I wish I were there in person with you and could be spending the day with you. I'll just say that I think you have it exactly right. I mean, I worried, first of all, that data that doesn't feel like it's sensitive at all will be revealed to be sensitive because artificial intelligence and techniques like that will make it possible for you to infer something that is sensitive from something that doesn't seem it. And then second of all, once that inference has been made, one wonders what laws would possibly govern it, right? Because it's one thing to say that you have given a company information about yourself and they've used it in a wrong way. But let's say you give information about something and they create an inference that's their own observation. How is that regulated? And I think that's a very tricky question. I'll stick around to hear some other people's responses, but then I do have to hop off, and I appreciate all you all.
So maybe hear one more expert's response, and then we will have a concluding remark. Anyone wants to jump in? Professor Dr. Yang?
Well, I think For the medical data, I think there's no non-sensitive data. Every medical data is sensitive data to me. Yeah, yeah. So we really need to very take care of the privacy in the medical data.
Okay. Yeah. Okay. Yeah. Any different point?
Okay. Maybe I talk about something. I talk while I was thinking. Okay. I think I know that the most medical data are really sensitive because it related to patients' healthcare situation. So one way it mentioned that we will take out or extract some of the information that tends that become sensitive. I think it's because we use the big data and the joint computation. That is so that can infer something. So if you would like to, so for as long as the data is big, huge, and it's combined with different of data, I will consider that is somewhat of sensitive because from there you will be able to infer more of the information from there. But so in order to make the data less sensitive, we have to break. For example, if the patient have the EEG signal, they have the heart rate and heart rate of something, and they have their chest rate. And then we should separate. If we separate them, that's EEG, and then we disconnect the EEG signal to the patient, disconnect the EEG to the chest rate. Then just EEG alone, maybe it will be less sensitive because you don't know who is it. That's what I'm thinking. Okay, so one way is try to, because to develop an AI technique, there are very kinds of approach. One kind of approach is just based on the EEG signal to detect something, based on image detection. That is one kind of research. Another kind of research is kind of cohort of data and they try to do the mining or extraction of some information. That is another kind of research. So if we try to break down our data into different fragments, so that to break the linking between the different set of data, we can reduce the sensitivity or the sensitivity or the possibility of it. So so my thinking is we may focus on this way and to see whether we can come out some of the less sensitive data and then the open and the easy for our to use. But of course, I know that all the concept or all the agreement has to come out from the discussion. We have to come out from the bottom up instead of top down. We need to have include the hospital, the president, the researcher, even those concerned about the privacy issues, those social group people. We need to talk to them. And also, I think we need more of the education. We need to talk to our more common of our people to let them know that if we don't, because the way we are developing, we are trying to benefit human. We are not trying to get something from it. We are trying to benefit the human, the healthcare. So we need to let the most of people understanding we are doing that. You can miss. If we miss, then that is harmful. Actually, it's harmful for you. For example, if some group of people, if our government decided that this group of people, because of the privacy issue, they should not be included, I think that is unfair for this group. Because in that case, I cannot provide this technique benefit to you. So you kind of, this group of people kind of be excluded from this benefit. So if we try to persuade from this view to more of our common people, for them to understand and let them know that what would be the effect to our human if they got excluded, then they will be understanding. And then so under the common interest and common understanding of the kind of, I mean the good willing, the understanding, then maybe we can persuade more and more people and to work together. That is my perspective.
Okay. In the interest of time, I'm not sure if Professor Wu wants to chime in, but very briefly.
I think the question is very difficult because the risk is very not easy. It's not easy to calculate or to evaluate it. One of the cases I've read it like the CSI TV show, something like that, because the medical image, it shows there has no name, no ID, something like that. But the problem is that there's a device in the heart with a serial number,
Okay.
and they can identify who he is.
Yeah.
So the risk is very hard to evaluate it. So I think the law is only part of the regulation or the health data governance. The important thing is that, just like Professor Calo has mentioned, individuals sometimes undermine the risk. So how to communicate with individuals with the risk, and they make them understand what kind of risk they will face when they provide their information, and what kind of benefit they will be benefit from. I think that's important. So that's why I'm saying that the transparency or the communication is very important in this scenario. Thank you.
Thank you. And I do appreciate Professor Calo for staying till the end, despite your being hungry. But maybe just one sentence for everyone to conclude, okay? Yeah.
Yeah, so if I may start, I mean, I know I'm standing between you and lunch because it's 12:10 p.m.
Everybody is
there.
hungry. That's fair.
And you're standing between me and dinner. But no, it's been a delightful event. I've learned a lot, and I really appreciate being included. And I'm glad to know that an international group of scholars is thinking through these important challenges. So just want to say thank you for the opportunity and for engaging on this important issue. And I hope to see you next time in person.
Yeah, we hope to see you in Taiwan. Okay, thank you.
I hope so too.
Yeah.
All right. Good night.
Okay, yeah. Okay, one sentence from each of you. Just one sentence.
Okay, just one sentence. What I would like to say is we should, I think AI can be work on a different area, but if AI work on health improvement, that is certainly a benefit to us. So I would like to say, let's work together to make AI truly benefit to our health.
Okay.
Yeah, so for everyone, I think we want to make sure that you do have the good intention to collect and use data. So we do have a very good data governance. Yeah.
Okay, thank you. And Professor Wu?
The utilization of data and the protection of privacy should not be an all or nothing choice. And it's difficult, but it requires intelligence of us to work together to figure out how to balance that.
Okay, thank you. And let's give a round of applause to all our panelists. Yeah, thank you for all for participation. Yeah.
Thank you very much, Professor Xu, and for moderating the session and for a very lively discussion. And at the same time, our deepest appreciation goes to all the panelists for your inspiring presentations and insights. And before we close the session, I will kindly want to ask all our panelists and Professor Xu to come to the forward of the stage. Let's have a group photo together. And although Professor Citron and Professor Calo cannot join us due to the time, we are still very pleased to have them with us for the very in-depth discussion. Okay, let's gather to the center a bit. Okay, look to the camera in the front. Okay, ready, set, smile. Okay, for the second one, let's thumb up together. Perfect. Okay, so it's of true pleasure to have so many experts at home and abroad. Do we need another photo from a different angle? It's okay. Okay, thank you very much for all our experts at home and abroad with very diverse backgrounds to join us today. And now, ladies and gentlemen, we will have a 45-minute lunch break. The afternoon session will begin at 1 p.m. And after lunch, everybody is welcome to come back to the venue and take a short break. And due to space constraints, I will like to ask our on-site participants to kindly stay in your seats for just a moment. I'd like to first invite our guests and speakers to follow our staff to the fourth floor conference room for lunch. 那我们因为场地限制的关系，我们请与会的同学还有嘉宾暂时在座位上稍作等待。我们先邀请我们的贵宾还有讲师可以移动脚步，跟随我们的工作人员先来到我们4楼的用餐地点。Thank you very much for your patience. Ladies and gentlemen, the International Symposium on AI Research and Law will begin in 1 minute. Please take your seat and kindly turn off your cell phone or switch it to silent mode for the whole conference to move on smoothly. Thank you very much. Distinguished guests, ladies and gentlemen, welcome back to the afternoon session of International Symposium on AI Research and Law. In this session, we have also scheduled 2 keynote speeches and panel discussion. In the first presentation, we are honored to have American legal expert Professor Frank Pasquale at Brooklyn Law School to be our speaker. Professor Pasquale specializes in law and technology, law and artificial intelligence, health law, and law and political economy. He currently serves on the U.S. National Artificial Intelligence Advisory Committee, which advises the President and the National AI Initiative Office at the Department of Commerce. Professor Pasquale is recognized as one of the leading, outspoken, and also provocative voices with regard to artificial intelligence and the law. And today, he will be presenting to us the topic of medical AI and human expertise in the age of automation. And now, without further ado, let's give a round of applause and welcome Professor Pasquale.
Thank you. Well, thank you so much. It's really an honor and pleasure to be here. I really learned a great deal from the keynote speeches today, friends and colleagues from the US, and also learned a great deal from the excellent conversation between Professor Xu, Professor Shan, Professor Wu, and Professor Young. And I think that being able to hear these expert voices to understand the unique issues now facing Taiwan and the US and many parts of the world is helping us to advance the ball with respect to AI and research in it and trying to improve the lives of everyone. And I think particularly in the realm of medicine, we have incredible opportunities here. And what I want to try to go through today is to think about some potential really positive uses of AI in medicine, building on some of the research like what Professor Chan is working on right now in terms of trying to better understand pathology, better avoid bad outcomes, and also trying to make sure that we have good regulation to ensure that if something, that when things are needed to be validated, or if there are other sort of issues that need to improve the AI, that we have the reimbursement policy and the liability policy to ensure that occurs. Now, to start, I'm going to start with an opening question, and I won't get into sort of the futuristic AI in this talk. I want to think about something that's very sort of practical and direct about problems that we're going to be facing with the AI and robotics of the present. And my hypothetical here is that we all know that if a surgeon's hand slips with a scalpel and a tendon is cut, our sense is that that's the responsibility of the surgeon. But what we hope for with AI are the types of machines that would allow us to augment the surgeon's capabilities so that the surgeon does not cut, say, a vital tendon. But if we rely on machines in that way, are we going to face a situation where if they go wrong, who is the responsible party, right? And these are hard questions because on the one hand, we might say that this surgeon is doing much better than the typical surgeon, right? The typical surgeon may just be using their hands and not providing the extra safety. And so we might say, don't hold the surgeon responsible. They were trying to be extra careful. But then we might say, has the surgeon vetted the avoidance routine or this AI enough? And we may also say maybe we need to hold those people who've made the AI responsible. But then others would say, wait a second, we're just at the beginning of this technology. Let's give it a little breathing room before we hold them directly responsible for bad outcomes. They're trying, right? So that's an initial question. Thinking about how this sort of question can be posed algorithmically, I thought I would add a chart from a great article by Professors Price and Gerke and Goen called Liability for Use of AI in Medicine. And I like the chart because, particularly in AI in medicine, because what it tries to do is to present in an almost algorithmic fashion how the legal system should make decisions about algorithms, right? And we're going to see this sort of like mutual influence of AI on law, of law on AI in many scenarios. As you can see from this chart, essentially the problems are in red, right? If the standard of care for providing in medicine if the AI recommends the standard of care and it is correct, but the physician rejects that recommendation, and there's a bad outcome, there's injury and liability, right? But if the AI recommendation is for non-standard care, it's incorrect, and the physician follows that and it's a bad outcome, injury and liability. These yellow areas, I think, are going to be the ones that are going to be increasingly important to legal systems to address. And I'll try to, in the rest of the talk, give some examples of where we might go in those yellow areas to better understand the future of, say, liability and responsibility in AI medicine. Now, another version of this that we might consider is AI in the mental health context. And particularly with the rise of chatbots and the hype over ChatGPT, we're seeing some really rapid implementations of this type of technology. I think there was actually a report on Twitter of someone who tried to use ChatGPT to help patients with mental health crises. I mean, which is clearly not an indication. And so we wouldn't want to see that be go too fast. But in areas where it has been relatively well vetted, there may even be some issues arising. So for example, you may have a situation where a counselor can tell a patient with some substance use disorder like alcoholism to use an app to track cravings, states of minds, etc. But, for example, the app may recommend certain actions in case the counselor cannot be reached. And so here again, you see a possibility of an AI being used where the doctor could not be available. And on the one hand, we might say that doctor is being very responsible by trying to make sure there's some AI help. But on the other hand, we might say, wait a second, if it does something wrong, like recommending alcohol consumption to someone in a manic episode, and that results in harm, that either the doctor or the app or both have to be responsible, right? And setting that level of responsibility, I think, is going to be really key. Do we set the responsibility at a level of negligence? Like, do we have to prove something was done wrong by the maker of the app in order to hold them responsible? Or do we say, this is such a sensitive context that essentially the standard of care is, or that the liability standard is a strict liability standard, where if anything goes wrong, the maker of the app is responsible for at least some damages. I have argued, based on my New Laws of Robotics book, that where the app merely complements an existing human professional, negligence should be the standard. But if the app entirely replaces the professional, strict liability should be the standard. Okay? And I would love to have more further conversation about this proposal. But I think it's a useful proposal for now because what it helps to do is to encourage the use of the app under the guidance of persons who are domain experts. And this piece will be coming out in the Academia Sinica Law Journal in the next few months. So I'll be sharing that with, and I'm happy to share it with others if you want to contact me about it. I think this is different. You know, this sort of vision is very far different, though, than the AI in medicine dream, right? And this is an image from Star Trek. This is one device from the old Star Trek. And it's an image of the new Star Trek, where the goal of Star Trek medicine is that you just have a machine that diagnoses and cures you, right? And so, and I think, though, that and I will confess that my proposed standard could keep us a little bit away from that because it's so focused on human-machine interaction. But I think increasingly what the leading scholarship in AI is recognizing, just as Professor Calo said earlier today, is that AI is not a thing, but is a socio-technical apparatus of machines and humans. And that because of that, we want to try to encourage that ongoing mutual engagement between humans and AI and machines to improve it. Now, one of the reasons I go in this direction is because of a long-standing problem that we've seen in the past of AI, automated medical advice, trying to replace physicians. And if you were to roll back the clock about 15 years or so, there was controversy about how Google was answering medical questions. So people would ask medical questions, ask Google a question like, should I use colloidal silver, right? This is something, just to give my perspective, I think it's a bit of a quack remedy, but I don't think it's very valuable. But they'd ask it, and they would get results that would say things like, well, it's used to treat infections, you know, all these different things, but also have a result right under it that would say, no, it's not considered safe or effective for any of the health claims that manufacturers make, right? And Google's initial position was, we just provide a menu of options for people, and they can decide, right? You can decide whether you believe the top one from WebMD, or the next one from, or the snippet from WebMD, or the snippet that is from another source. But ultimately what Google started doing is they moved to the right-hand side, see with the mobile phone, where if someone asked about, say, pain in their throat and thought they had tonsillitis, they would get a card that had been prepared by doctors. And so the idea was that we wouldn't just throw people out to the search engine to figure out what they could make sense of as the most authoritative result. We would let them, we would see that Google would seek out the advice of experts to provide a vetted gateway, initial entry point into the information here. And I think that's a very valuable idea in terms of considering how we might frame the future provision of medical information online. And I think it's something that's going to be a particular challenge and particularly important as people start looking for one-shot answers via ChatGPT as opposed to sets of results on Google, right? That's going to be a big challenge because people are just going to say, I've got a pain in my throat, what is it, right? They're not going to want to sort through it. And so I think this is an initial answer, is to bring in experts for at least the initial answer to the problem. Now, in thinking about the future of AI, one of the things that gets emphasized is, what about decisions that are, say, beneath the level of diagnosis by a medical professional? Say work done by paraprofessionals, right? And I hope you'll forgive me for the hierarchical nature of this discussion, but I mean, I think there is something of a hierarchy of medicine, of, say, doctors and nurses, of those who are assisting them, assistants in various forms, those that are on the front lines of the administrative staff, et cetera. And one of the goals for AI has been to use something like Alexa to assume drug distribution, discussing symptoms and feedback, coordinating hospital post-op care, et cetera. Right, so this might seem like a relatively straightforward use of AI to free up labor in the system. But even this is something that could raise some complicated issues, right? So if you are using AI, for example, to help someone discuss their symptoms or whether to get follow-on care at a hospital, it can make mistakes, right? There are many US liability cases about insurers who won't approve payment for treatment of patients. And they are on the hook when the person's deciding those things lead a patient to avoid a hospital when they should have gone to the hospital, right? So that's one issue that can come up. Also, like institutional liability, right? I think one reason why this sort of rollout is slow is because I don't think Amazon wants to have that type of liability. I wrote an article about 10 years ago, exactly 10 years ago, that was about Amazon's contracts for cloud service provision to healthcare providers. And what was so fascinating about those contracts is that Amazon was very good, and all these large tech companies are very good at shifting liability onto another entity. But in US healthcare law, there are doctrines known as presumption against exculpatory clauses that make it very difficult for any healthcare provider to shift liability or to shift sort of a disclaimer onto a patient, right? The liability sticks. Even if you ask a patient to say, sign away all liability, the healthcare system is seen as important enough that you can't sign away things that easily. And that, I think, is something worth preserving, actually. I think it's worth preserving this important principle that people shouldn't be able to sign away their rights to sue. I'd also note that maybe there could even be malpractice in some of those hypotheticals that I gave. Informed consent is an interesting one. Glenn Cohen, a professor from Harvard, has written extensively about informed consent and AI, and whether a doctor using AI to treat someone or a health system doing that needs to get their consent, that they know that an AI is the one making a decision about them. So that's a very interesting issue. And finally, privacy regulation, of course, right? Alexa will gather a lot of information. And we heard from our first two talks, especially Professor Citron, about how little this information is regulated in many contexts. But at least in the US, once a company like Amazon starts sharing data with an institution covered by our Health Insurance Portability and Accountability Act, which is our health privacy law, then the tech company becomes a business associate of the covered entity, and then the health privacy law applies to the tech company. Right? So this is a very interesting way in which this healthcare, again, becomes an area where it can be hard to just sort of move fast with AI. I'll also note that clinical decision support systems are another area that I think are quite important for us to consider as a precedent for past regulation of computers and machines assisting individuals in making decisions. Right? And any computer system that deals with this sort of medical knowledge can be intended to provide decision support. And we can learn, I think, in implementation of AI about how to assign responsibility and how to invest in them. I think learning from the past is so important here. And just moving forward with that, you know, if we think about this type of computational intervention in medicine, I think generating alerts and reminders is one example of where we may see the past of clinical decision support moving into the future of AI. It won't necessarily be that the AI is making a decision about the patient, but that it can alert people to a state of danger. And this is something we already see, for example, with just if you've been to a hospital lately, you'll notice that like there's lots of beeping machines, right? And I think right now there's a bit of a cacophony of beeping machines, a sense that there's too much noise and not enough signal. The promise of AI could be in a way to try to develop more signal from the noise of extraordinary or unusual events that lead to machines alerting people. Also diagnostic assistance, therapy critique and planning, and we've heard earlier a lot about image recognition and interpretation and the promise there, right? I'd note that I would just contrast medicine with places where there are more rapid, there's a case for more rapid automation, right? I think that in the case of manufacturing, logistics, transport, mining, and agriculture, there are lots of opportunities to essentially robotize what's going on. And I think that part of the burden of developing AI in medicine is to distinguish what's different, say, about different aspects of medical practice that distinguishes it so that it cannot be totally robotized, like this Baxter robot putting gears into a box. I think the main way that, the main reason for that is that medicine is more in general than just pattern recognition, stimulus and response, right? I mean, if anyone has ever gone to a doctor and talked to them about their treatment plan, you've probably had a sense of this, right? If you might have, for example, I've had an experience of a bad knee, right? And so, or of having a little bit of having some knee problems. And then you go to the doctor and one doctor may say operate, one doctor may say do physical therapy, one doctor may say something else, et cetera. You know, so it's because it's about you and your body. The patient has a sort of co-determination there. That's one element of it. But another element of it is that there is so much, AI itself could be creating more labor in the medical system than solving labor problems, right? Imagine, for example, that you have, when you have imaging, maybe old images, and this is why I put this imaging slide on the screen, maybe older images would be about pixels, say two-dimensional images of different bodily organs or parts of the body. As you get more computational capacity, you can do voxels, right? You can do three-dimensional imaging of parts of the body. And this is why Leslie Wilcox, a British industrial scholar of industry, has said that AI will cause infinite work, not the end of work, right? Because what the AI is doing is it's bringing in so much new data to be considered and so many new edge cases and different ways of categorizing, say, the nature of illness, the advancement of illness, the susceptibility of illness to treatment, et cetera, right? And just to, again, get an intuitive sense of this, it may well be that, say, a patient who has congestive heart failure should be on certain drugs. But then when you ask, well, should this patient, who is 77 years old, who's on 6 other drugs, who has 3 other comorbidities, and who can walk at a certain rate with a certain heart rate with a walker, should they be on the drug? And if so, how much, right? These, to me, are the types of questions, the sort of potential personalized comparisons of treatment effectiveness that are incredibly promising with AI. And I want to see more computational capacity devoted to these. But of course, we're going to need better data, and we're going to need better rules on data, right? We're going to need better rules on data to make data more liquid so that we can do those sorts of things. But my broader theme is just that for the foreseeable future, given that there's so much data to parse, we're going to need technology complementing professionals and professionals complementing technology in these different areas. I'd also note that, one way of thinking about this as well is to compare making things versus healing people, right? This idea of the product versus the process, right? Modern automobile plants can employ industrial robots to install windshields. And this is quotes from David Autor's excellent article, Polanyi's Paradox, which I think really gets into the idea of what can be automated and what cannot. But it's hard to imagine windshield replacement companies using robots to install replacement windshields, right? I mean, maybe someone will come up with this and it'll be a great business, and David Autor and I will be proven wrong, but so far you don't see that happening, right? I think because it requires so much adaptability than any contemporary robot can approach. So we could go in that direction. And part of the question for AI as well is, where do we invest our funds, right? Do we invest in, say, the windshield replacing robot, or the comparison of treatment effectiveness AI, et cetera? These are hard questions for those leading scientific grant organizations and others to decide. I wouldn't want to be in their shoes, because they're very, very hard to decide. But I think they're the types of questions I hope we see more of. I also want just to be sure to note the problem of the promise of AI, but also the problem of overclaiming for AI, right? So this is a slide of a landscape of clinical prediction models that I believe was a meta-analysis of a meta-analysis, right? So in each of these areas, you could have a meta-analysis of like chronic obstructive pulmonary disorder prognosis, right? 408 AI models for identifying essentially how will someone's COPD proceed, right? Going down to, say, 232 models related to COVID-19, et cetera. There's tons of these models, huge excitement about all of these different models and how they might be used in medical contexts, and a desire for more investment in them. But some issues there are some real issues here. So MIT Technology Review recently reported, this was in 2021 admittedly, so it was early days, that hundreds of AI tools have been built to catch COVID, but none of them helped, right? And so this is where we have to be sure that we are on track to proper validation. AI, I've used in my robotics book, I've talked a lot about the analogy between AI and drugs. And I'm not ready to endorse something as rigorous and as costly as the clinical trials, drug clinical trials for AI yet. But I do think it's useful to sort of think about what would be the necessary standard of substantiation. I think it's somewhere between what the Federal Trade Commission has announced as its substantiation standard in the Palm Wonderful case and what we're doing with the FDA now for drugs. And so thinking about what that standard of substantiation is helpful in order to combat what Deb Raji and Andrew Selbston, co-authors, have called the fallacy of AI functionality. Too much of the current debate sort of is premised on the idea that it will work. And I even thought about this today when we were talking about AI that knows people or that can know people and make it, and I tend to say when AI attributes something to a person, be it an attitude, a belief, a condition, it's attributing versus knowing that about the person, right? I'm starting to change my language about AI and people. I don't say AI knows that about you, I say AI attributes that to people. because I think what the AI is doing is closer to a form of power than it is to a form of true knowledge in many scenarios, right, with people. I wouldn't say that about a lot of what AI is doing in other areas, but I would say that about some of these other characteristics. I'll note too that we're going to see so many examples of medical AI supplanting or supplementing traditional professionals, right? We're going to see examples in care homes where the traditional medical professional role is a caregiver attending to patients, and as we have larger aging populations, we're going to see more pressure to have things like a robotic seal or a care coach avatar interacting with nursing home residents, because sometimes there just isn't the amount of labor available to do the job. And I think this, especially, I wrote the book before the era of labor shortages. I think we're going to see even more now. You know, we see just very low unemployment rates in many parts of the world. But of course, we could also address this issue by changing our immigration laws in many places. So I think that considering the full range of policy options in these realms is essential when we're thinking about where to deploy AI, where not to. Roberto Simonowski has developed this idea of the death algorithm as a matter of social theory, which could complement physicians who decide whether to maintain a patient on life support. This was an issue that also came up when we were discussing the possibility of rationing ventilators and care in the US during surges of COVID, right? The idea was if someone has absolutely no chance of a positive prognosis, then it doesn't make sense for them to be using the hospital bed that someone with a better chance could be using to better effect. And even with the distribution of a drug like Paxlovid, that could be done. But clearly, you know, if you start using these type of algorithms for the allocation of that level of benefit and burden, there's got to be a lot of transparency and a lot of due process. And I think it may be a case where only sort of transparent expert systems, as opposed to big data, may be allowed, or at the very least that any sort of big data approach would have both its methods and data available for public inspection. If we're going to decide, for example, using this type of data, how to allocate either medical care or the insurance coverage for medical care. Because that's clearly the next step, right? It may be that the doctor can be the professional, but the insurers are going to be the ones that are ultimately deciding whether to cover something or not, be they public or private insurers. The next example I would give is, say, if a dermatologist decides if a mole is cancerous. And the New York Times a few days ago had a wonderful article about Hungary is trying to develop a standard where every doctor, oncologist trying to make, or radiologist trying to make a breast cancer diagnosis is supplemented by AI. And parts of Canada have this goal as well. Because at present, the estimate is that 20% of breast cancer goes undetected on a first effort to detect it. And one of the studies said that they could increase the chance of detection by 13%. And so that may not sound like too much, but if you think about thousands of persons being screened, 13% could literally lead to, again, thousands of persons in the country, perhaps tens of thousands or hundreds of thousands in the world, catching the cancer at stage 1 or 2 as opposed to stage 3 or 4, which is really a world of difference, right? And so that, I think, is a terrific thing. And I think particularly with this mole example, that's yet another example where the power of pattern recognition, as Professor Calo talked about, you know, patterns being so critical, I think that pattern recognition is really key. And I'll also note, a doctor deciding, say, if 2 drugs will interact with bad effects, we already have lots of clinical decision support software advising on drug-drug interactions, to the point where that, I think, is something like a standard of care for hospital pharmacies, for doctors, given computerized physician order entry for pharmaceuticals. So, you know, thinking about this sort of thing, if you were to consider about this complementary drug-drug interaction issue, I think that we have examples of litigation over this issue. And I think when we consider the future of AI, we'll look back to some of the case law on drug-drug interaction software, and it will help guide decisions about when the AI should be responsible, when the doctor is responsible, et cetera. And just to give an example of what these look like, you know, this is an example where the drug, this is, of course, an old interface, right? But it gives you a sense of how a computer may just tell someone, you can't order the 2 drugs together, the isosorbide and the sildenafil. you have to cancel one of them, right? This is an example where the computer is taking a very active role. Another example is where you can put them together, but if you do, you have to give a reason for override. And it could be that we're all going to see these types of warnings in more and more of our lives. You know, you might imagine you're driving on the highway and you go over 100 kilometers per hour or 150 or whatever the speed limit is. The car may say, "Why do you need to go so quickly, sir?" Right? and I think this is a very interesting question because there's a whole new book on this called Data Driven by a Cornell information scientist named Karen Levy. And she's written how these sort of systems at first seem to be promising to make driving much safer, but have made the process of being a driver incredibly hard for truck drivers now. And so balancing not only sort of the societal goal of safety, but also what are these AI systems going to be like in our workplaces is really critical. And I recently did a piece for the European Trades Union Institute on some initial steps toward making AI in the workplace humane. And I think that there's other great work out there. California has proposed a law called the Workplace Transparency and Accountability Act. Brishan Rogers has a book. Ifeoma Ojunwa has a book called The Quantified Worker. You're seeing enormous interest in this topic because we're all going to be affected by it. And then, you know, the last example is just if you have this type of alert, just, you know that we recommend to adjust, but we're not going to force you to adjust the drugs in the level 3 alert. So these, I think, are useful examples of like where AI is going. I do think, though, that, you know, just to bring home my point earlier about substitutive AI and potential issues of liability here, that, you know, we may have some CPOA systems of the future that do decide everything in more contexts. And when the physician is no longer responsible, they cannot override the system. And it may be appropriate to impose strict liability even up and down the distribution chain of such a substitutive AI. So we may see that, you know, is the AI, if it sort of starts taking over roles, taking on more responsibility as well. And just finally, you know, this is just one other way of thinking about the different forms of interaction or decisions that can be made at different levels with the AI. I'll wrap up just a second, but I think that, you know, the last points that I'll make are just, I think that the question of liability is a really key one. I think what I've tried to do today is to answer some of these questions, but I think that the larger debate that we're going to have in the Q&A session, we can go deeper, for example, into the question of why, oops, sorry, sorry about that, that we can go deeper into the question of where to impose strict liability, where to impose product liability, where to impose provider liability, and then focusing on physicians. And also, I haven't even gotten into the First Amendment protection issue, but I want to talk a little bit about free expression and the role of free expression in providing medical advice, because that may be a sort of wild card if you have a collision course between, say, imposition of liability, strict liability on providers of certain medical diagnostics, and their argument that they should be just seen as like a book that people are consulting that should not have any sort of liability, that's just their opinion about a given scenario. And that reminds me a bit of what Professor Calo was saying earlier about hacking and when hacking is your free expression right. So we'll come back to that, but I want to leave it here for now. So thanks so much, and I'll hand over the mic to a distinguished keynoter as well, Professor Deeks. Thank you. Great.
Thank you very much for Professor Pasquale. And for now, I think we still have a couple of minutes left, so we can maybe open the floor for some questions. So for our on-site participants, if you have any questions for Professor Pasquale, please just raise your hand. Thank you very much.
Great.
Yes?
Hello. Okay, thank you, Professor Pasquale, for such a good, such a detailed presentation. But since the part for allocation of the liabilities has been really gone through rather fastly, I really wonder how do you really allocate ultimately between the manufacturer of the whole machine model and also the decision maker within the medical process, so that you may ultimately trace back to someone to to cure the damages and to affirm the liability within and make sure that anyone is harmed can be remedied with that. Thank you.
Yeah, no, this is a great question. Thank you, Joan. It's been a very important legal question here about the allocation of responsibility in a scenario like this. And I think that, if I were to consider, I mean, I have one dodge, which is to say that it's very contextual, but I won't go entirely in that direction. I think that the part of the issue that we are facing is what the rise of AI in medical practice is calling on us to do is to get a better and richer picture of the allocation of decision-making responsibility between the professional and the AI, right? And so I feel like ultimately we're going to have a scenario where we have to hold somebody responsible, and we might hold many people responsible. And the question then becomes, how far up the chain of influence do you go in terms of, say, an AI? And let's keep in this because your hypothetical was about an AI giving some form of advice to a doctor, right? And so I don't want to be in a world where we have a doctrine of, say, competent human intervention that would render it so that whatever the doctor says is ultimately the only, that they are the only source of responsibility, that the buck stops with the doctor. Because I think that a doctor has lots of consultations with, say, existing resources where they're more in charge of what they look at. But once the AI comes into the picture, that it takes on a special level of responsibility because it's trying to give a portrait or picture of the world. And just to give one other example of this, of the contrast that I think is more ready to hand, imagine if you make a bad decision based on Google search results versus if you make a bad decision based on what ChatGPT tells you, right? The Google search results, Google is very, I think, correct to say, or could more readily say, I'm not going to say it's correct to say, but it could more readily say, more accurately say, we just gave you a bunch of options, you were the one who chose which one to believe. Versus with a chatbot, it's like, here's what you should do. Here's the state of reality. Here's the level of danger of this drug. Here's whatever, right? And I think that's part of the phase change that we're seeing now. If something like ChatGPT becomes the default standard for search results or for trying to search for information, then that becomes something where they're taking on an enormous amount of responsibility because they're trying to give a certain picture of the world or to recommend a certain course of action. And so therefore, I think that the way that I would frame it would be, to the extent you had something like that level 3 alert that I showed, that was merely advisory and that was merely giving information, much more liability should remain with the provider than with the care provider, the doctor. We'll just call them the doctor for now. More responsibility with the doctor and less responsibility on the provider of information. Maybe no responsibility, right? And that's also the principle behind some interpretations of CDA 230 as well. But to the extent that it is saying, this is what you should do, this is definitely what you should do, and certainly to the extent to which it says, this is what you must do, then you have to shift more responsibility to the AI, even if it might say it's merely speaking or merely offering a view about the world. And I think the reason for that is because if you have too much of, say, a free expression out for these things, then they start taking on the role of professionals without the responsibility of professionals, right? If I were to just put up a sign and say, hi, I'm Dr. Pasquale, and I will cure you, right? I have no medical training, by the way. If I were to put up that sign and give someone advice, they came in with melanoma, and I said, yeah, you don't need to worry about that, it looks fine, and then they had a terrible case of cancer, I would be sued, even if I could say, that was just my view, it's just my view, and I just gave them my opinion. Because by calling myself a doctor, I have to take on that responsibility. And I think there's something similar in the AI context. So I think that spectrum of liability is where I'd go with. The spectrum of liability is one from whether it's actually doing the thing, whether the AI is actually sort of giving one view of reality, making one decision, or if it's merely an information provision tool. And that would be how we'd have a liability spectrum there. So thanks.
Thank you very much for the very detailed and very inspiring explanation to the question. And unfortunately, due to time constraints, we'll have to close the Q&A session for now. So once again, thank you so much, Professor Pasquale, for providing with us for a very inspiring presentation. Thank you very much. So after hearing Professor Pasquale to sharing with us and also shedding light on how we can make very positive use of AI technology in terms of medical practices and also put forward some of the challenges we might or are encountering right now, and also put forward a mechanism, a system framework that we might be very helpful for the practices of smart medicine. Okay, so thank you very much for that. And moving on for the next presentation, we are very honored to have Professor Ashley Dix to be our presenter. Professor Dix is an expert in international law, national security, intelligence, the law of war, and the impact of artificial intelligence on international law. And she currently serves as the University of Virginia Law School and on the State Department's Advisory Committee on International Law. And today we are very honored to have her to join us in person. And now the topic she will be sharing with us is the legal perspectives of explainable AI. So now with a round of applause, let's welcome Professor Dix.
Thank you so much, and I'm really delighted to be here. So thank you to those who invited me, and I look forward to the conversations we're going to have about this topic moving forward. Today, I wanted to talk to you about this concept of explainable AI, which is sometimes abbreviated XAI. I want to talk a little bit about what it is, talk about why we need it, and talk about how we can all potentially shape what it looks like. So I will start by providing a little bit of background about my own work and what got me interested in explainable AI. And then I will spend a little bit of time explaining what it is and why I think we need it in many of the tools that we've talked about today. And I will offer a couple of comments about its use as, I think, a necessary, but not necessarily a sufficient tool for encouraging the responsible use of AI and enabling governments and industries, including hospitals and researchers and doctors, to use AI in a way that the citizens are going to support. So let me start a little bit with background. I am in the process of writing a book on the role of artificial intelligence in national security. So by that I mean a government's actions that it's taking in the defense area, in the intelligence area, and in the homeland security area. And my thesis that I'm writing the book around is an idea that democratic governments that are beginning to adopt AI tools in the national security space are going to end up operating in what I call a double black box. And I, of course, am drawing from Professor Pasquale's book on the algorithmic black box. And one thing that I want to do in the book is think about how we can make this double black box more transparent. So let me say a little bit more about what I mean here. In the United States and in many other states, many other territories, governments make national security decisions in secret. Why? Well, the government needs to keep its intelligence and its technologies and some of its activities secret to protect that information from making its way to adversaries, right? It's the only way that it can have those activities be effective. But that means that the government is necessarily keeping information from its own citizens, right? Which is a little bit in tension with a democracy as we usually think about it. So this makes it hard for citizens to oversee what their executives are doing inside this national security black box. Why is that a concern? Well, we want to make sure in democracies that our governments are operating consistent with what we think of as public law values, things like legality, things like efficiency, with competence, and with accountability, of the type of accountability that Professor Pasquale just ended with. And the nature of the national security black box makes that hard to make sure that our executives are acting consistent with these values. Our legislatures might have some ability to oversee some of what the executive branch is doing, but it can't oversee all of it because of classification issues. And our courts, at least in the US system, but I think also in other systems, have quite limited competence to assess some of these issues, and they've developed a number of doctrines and deference to the executive that reflect their reluctance to dive into the substance of national security decisions. So that's what I describe as the national security black box. And I think we are moving into a world in which we are going to be placing the algorithmic AI black boxes inside this existing national security black box. We are talking about governments developing advanced AI tools that use things like deep neural nets. This will increasingly produce accurate predictions and recommendations, but it is notoriously difficult for people to understand why the systems are producing the predictions that they are, right? So notoriously, these neural nets are often referred to as black boxes themselves. So in this national security space, I think we're going to end up with a double black box where actors who are operating outside the public eye, making decisions that will be deeply informed by AI, or in some cases, we might even have the AI tools themselves be the decision maker, not just a decision advisory tool. So how does this link to explainable AI? Well, I think one way to start to address the double black box problem is by seeking to use more explainable AI. So let me say a little bit about what explainable AI is. I'll discuss at a very high level of generality some of the forms it can take. Maybe I'll give you a couple of examples where we might start to see it being used. And then talk about how explainable AI can help manage the double black box. So even though my focus is on national security, I think many of these same concepts are relevant to medicine, so I will say a little bit about that as well. I think just as citizens want their government to act with legality and competence and as much transparency as possible, so too do a lot of patients want their doctors to act consistent with those same values. Okay, so what is explainable AI? It sounds like there are a lot of electrical engineers, computer science scholars, and researchers in the audience, so you, I'm sure, may know this better than I do, but for those who have not run into this concept before, here's what's described as explainable AI. As the algorithms are becoming more sophisticated, as they are being trained on larger sets of data, and as they are being fed through tools like convolutional neural nets, the workings of the algorithms are growing increasingly opaque. And yet, in a variety of contexts, including legal ones, which are the ones I'm particularly most familiar with, both those who are operating the AI systems and those who are affected by its predictions will want to know why it is that a particular AI tool reached the prediction or recommendation that it did. We also, of course, worry about flaws in these algorithms. We worry about the possibility that they were trained on biased data, or that the algorithms themselves are poorly crafted to produce unreliable outcomes. Hence, an interest in explainable AI, where the idea is basically to develop ways to allow humans to understand what factors were most important in leading an AI tool to produce the recommendation that it did. And you might think it's obvious that every AI system should, of course, be explainable. And it is also the case that important actors have been working on these tools for a long time. So DARPA, which is in the United States, the Defense Advanced Research Projects Agency, has been interested in explainable AI for quite some time. But we will have to make some level of trade-offs, at least where the current state of technology is, between accuracy on the one hand and explainability on the other. Convolutional neural nets are often more accurate than older models, but it is harder to see and harder to understand what the neural net is doing. It is hard to know what it is weighting most heavily. So to date, researchers have developed a range of potential approaches to explainable AI to try to resolve some of this problem. Some approaches try to provide relevant information to the user about how the model works. This is sometimes called approximated explainability. So it might give the user information about the data that was on which the system was trained. It might explain what family of model is being used by the system and how the computer scientists trained the model. It might also give users information about types of actors who received similar decisions or similar predictions to the ones being made about you. Some forms of explainable AI might allow a person to test counterfactuals. So that is to tweak different elements of the inputs to see if it produces a different outcome. So for example, if you, in a criminal justice setting, received a prediction that you are a person of moderate dangerousness, based perhaps on your age and where you live and how many prior arrests you have, then a form of explainable AI could allow you to say, well, if I had 2 fewer arrests, would I be deemed to be a low-risk individual? Some explainable AI is more focused on understanding the system generally. It's sometimes called global explanation, right? You're asking about how the system generally works. And some explainable AI is more focused on understanding the specific prediction that the system made, sometimes called a local explanation. So on top of those types of explainable AI tools, another thing that developers have to think about is the interface between the explanation and the user. That is, how does the system show the explanation to the user? Will it, for example, be reflected in a visual chart? Maybe in a medical setting, it might be a heat map showing which part of the X-ray led the system to predict that there was or was not a cancerous tumor. Will it be presented in text? Those are all different ways you could imagine the explanation manifesting itself. It will also matter the level of sophistication of the user. Right, so explainable AI that is going to be directed to and processed by some of our esteemed colleagues in the front row will look different from explainable AI for a layperson, such as a soldier on the battlefield or a patient who is in the hospital. Another thing that's interesting to me, and I'm curious about why this is the case, and I'm looking forward to doing more research on this, is that there have been some deployments of explainable AI in certain systems, and yet in some of those cases, the users are not turning to the explainable AI to try to understand the systems. So I'm curious about that phenomenon. So let me give you a couple of short, concrete areas where this could be a relevant tool for use. So the first is in the administrative law setting. In the United States, our Social Security Administration has used some AI tools to make determinations about who would be eligible for Social Security benefits, right? So these are benefits that a person can receive after she stops working, maybe because she has reached retirement age. And if someone wants to contest the amount of benefits that the system has recommended that they receive, how can they do so if the system that has made the prediction is effectively a black box? This is in some tension with the requirements of our legal system, where courts are generally allowed to examine the reasons why particular agencies made the decisions that they did. So maybe this is of a piece with Professor Calo's argument that there are some existing laws on the books that are not a perfect fit for when AI tools start getting introduced into the mix. So in the administrative law setting, I think many people agree that explainable AI is going to be an important part of the US court's ability to assess the Social Security Administration's decision. They will want to understand why the algorithms made the calculations that they did. I also think that that will mean that the agencies themselves are going to demand of their own computer scientists that they develop explainable AI in advance, because they know they are going to have to justify their decisions before a court, and our judges are generally not computer scientists, so there will need to be an explanation. In the medical field, we've already seen examples of AI tools being used for diagnosis and treatment, whether that is predicting the onset of sepsis or using emergency health records to try to predict the mortality risk of someone who's been admitted to the hospital. And Professor Pasquale referenced an article recently in the New York Times about diagnoses of lung cancer. AI may be better than some humans at those diagnoses. But surely doctors and patients, just like military operators, will want to know why the system made a particular prediction or recommendation. So in other words, if a patient turns to a doctor who has been using an AI tool to support his or her decision-making and say, why do you think I have been diagnosed with stage 4 lung cancer? The doctor cannot say, I have no idea why. I am just using an AI recommendation here. So I think there are some general benefits to AI. I think it will help persuade actors to use AI in the first place. I think it will help end users both accept certain predictions by the system and also potentially know when to push back or not accept the predictions that have been made. And I also think explainable AI can do some work in addressing the other critiques of artificial intelligence that we often hear, including concerns about biased data, in the use of flawed data sets, including concerns about automation bias, which is the idea that a person might accept a recommendation from a computer without question, even where the recommendation is in tension with their past practice and deep understanding of a field. And I think it can also help with dehumanization concerns. So I also think that explainable AI can help ameliorate the thing I'm most concerned about, which is our double black box. I think it can help us understand whether an actor that is deploying AI, often it will be a government, but often may be another user such as a judge or a hospital, to help us know when those actors are in fact complying with the key values that we care about. So in terms of legality, I think having a good explanatory AI system will help the subject of the prediction be able to better challenge bad outcomes. I think it will also reveal what factors the system focused on. And in some cases, that focus might be something that it is not lawful to focus on. Maybe it's an emphasis on race in a setting in which the law would preclude that from being a factor. I think it can help with, I think XAI can help with efficiency. I think it's a way to help computer scientists validate the model. And ultimately, if the AI model is really producing better outcomes than a human alone would be able to produce, then explainable AI will help people get comfortable with its use and potentially make the larger system more efficient. And finally, I think it can contribute to accountability, which is something that, that we have talked about multiple times today. Accountability being the idea of that you are answerable to somebody, that you are obligated to explain and justify your action and your inaction, and potentially be held liable for decisions that are badly made. So explainable AI can, I think, help users detect whether a recommendation is flawed and then decide not to use it. I think it helps patients know what the human decision maker would be relying on for her diagnosis. And I think more generally, it can help actors ascertain sources of error and who might be responsible if the decision is flawed. So how are we going to get to a point where there is more widespread explainable AI? I think that there should be a lot of actors who really demand explainable AI. I think, for example, we will start to see in the United States our courts be a source of demanding more explainable AI. It could be that our legislatures start to demand it, especially if they want to know what tools our executive branch, our military, our intelligence services are using. Congress, our legislature is a potential source for demanding explainable AI. But I think even inside the executive branch, there will be demand for explainable AI, especially actors like the Defense Department or an intelligence agency or Health and Human Services Department that has to decide whether to approve new medicines or new medical devices that use AI tools. I think doctors would want to demand explainable AI. They would want to understand what tools they're using. They are accustomed to giving explanations to patients and colleagues, and they will want to do so when they are basing their advice in part on AI tools as well. And I think patients should demand explainable AI because they will want to know when engaging with their doctors why the doctor made a particular diagnosis. I think explainable AI can be helpful in order to make sure that the patient's consent is informed. So I think each of these actors, all of us, are in a position to demand and start to shape explainable AI, its existence, but also its form and also its user interfaces, because we want the explainable AI to actually mean something to us when we're presented with the explanation. We've seen some governments start to move in this direction as a more blanket matter, and the European Union's General Data Protection Regulation contains what some refer to as a right to an explanation for decisions that are based solely on automated processing. So they're starting to get some traction there. So let me wrap up. I think that artificial intelligence holds a lot of promise at the same time that it holds a certain amount of treachery. I think we will see some people embrace AI too readily, and I think we will also see some people be overly cautious about embracing certain effective AI tools. And I think a partial solution to both of those challenges is to keep improving explainable AI. So I think explainable AI will be a necessary but not a sufficient accompaniment to effective AI tools. It is not a panacea. There will be times where people misunderstand the explanations, where the explanations may not actually be accurate, an accurate depiction of what happened inside the system. But I think good explainable AI will take different forms depending on the context and the recipient of the explanation. But this kind of technical solution, this kind of technical explainable AI, how did this algorithm produce its recommendation, is really only part of what we as citizens want explanations for. I think we also want deployers, those individuals or systems or government actors that are deploying these AI tools to help us understand other questions too, broader societal questions. Why are you deploying this? Why are you using this AI tool? Where are you using it? Who developed it? What limits does it have, and how are you making sure that you are only using it within its defined limits? And how heavily are you going to rely on these systems as opposed to your own independent judgment? How are the interfaces between human and machine going to work? And I think it's only once we understand both sides of the equation, the technical explainability and the broader questions about explaining when, where, and why you're using AI, will we have taken steps to minimize our double black box problem. Thank you.
Okay, thank you very much, Professor Dix, for the remarkable presentation. And now we will open the floor for some questions. So if any, yes? Okay, so maybe you can wait a second until our staff can hand the microphone to the gentleman in front. Thank you.
Hi, Professor. Earlier you mentioned that the AI might be put into the use for the national security. And you worry that we, the citizen, might not be able to oversee the whole decision process. So now you have this concept of explainable AI. So my question is, how reliable is this explainable AI? If this explainable AI provides some answer you are not satisfied, do you just live with the decision rendered by the AI? So because that, I'm thinking that you don't get both. I think on the one hand, we want the benefit offered by the AI. But on the other hand, we also worry that it might endanger our personal privilege and freedom might get sacrificed by using the AI. So my suggestion is, instead of debating how can we alleviate the ramification of using AI, why don't we just limit the application of in specific area that like rely on AI?
So that's certainly one possibility, is to that a government could decide to, or a legislature could decide that there are some areas of government operation where it is not suitable to use AI tools. I will say that I think the national security area is not one of those areas where states are going to decide that they should take uses of AI off the table. And in particular, I think the reason that it is less likely that we would see AI come off the possibility list in the national security space is that very often those national security operations are directed outside the country. They are directed against foreign nationals in foreign territories. So the kinds of protections that we usually think about, the constitutional protections, civil rights protections along the kind that Professor Citron was talking about, those are, we think about as part of our domestic societal contract. And so there, I think we will be particularly cautious about using what we might think of as unsafe or improper AI. I think we ironically have less incentive to be really careful about the AI that we're using when it's directed against others. And it's that concern that is actually motivating my interest in making sure that the systems used by democratic governments are still attentive to some basic norms, ethics, values, even though the targets of the AI systems will likely not be our own citizens.
Okay, thank you very much. Is there further questions that you want to keep for Professor Dix? No? Okay. Is there any questions? Yes? Professor Liu, thank you.
Professor Dick, thank you so much for the wonderful presentation. My question is that although you've mentioned a lot of benefits for adopting explainable AI, what kind of incentive do you think is necessary for AI developers or for AI operators to adopt explainable AI? Do you think the market has provided enough driving force for that? And in terms of the field you specifically mentioned, national security, I think that compared to other domains in administrative law, national security is probably the field that the law allows certain degree of secrecy. So that's probably the reason that you think it's kind of black box. And what kind of mechanism do you think, or what kind of incentive do you think that the government, especially the executive branch, will voluntarily adopt explainable AI in terms of national security decision making?
Great, thank you for those questions. I think it's an excellent question. What incentives do we see that might produce more explainable AI? And you suggest that the market is one, like the commercial market is one possibility, and I think that's right. I think everybody in this room, as AI starts to infuse our daily lives, is in a position to decide, or you're in a doctor's office and the physician says, well, I just used some AI and the recommendation is that I give you medicine X, for you to say, why did the algorithm make that recommendation? What kinds of data was it trained on? Was it trained on the data of 80-year-old men 10 years ago, or was it trained on the data of people our age and contemporary and so on? So I think we're all in a position to start to demand it, and particularly when we're thinking about commercial products, choosing between one that is more transparent to us in understanding how it works versus less. The second part of your question was about the national security space. And here I think the incentives are different, but I do think that there are incentives to adopt explainable AI. So if you're a military commander and you have a system that is using AI to help predict where your enemy's troops are moving, you only want to use and rely on that system if you have a high level of confidence that it works. Because if you're using crummy AI, you are going to walk into, you're potentially putting your life at risk and your entire battalion's life at risk, right? You have actually very high incentives to want to make sure that the system is, has been verified and that you have a trust in it that is often enabled by an explanation from the system. And I think same way if you're thinking about intelligence communities, they have every incentive to make sure that they're only using systems that are accurate, that they can accurately predict that an enemy force is moving a tank or a battalion of tanks from A to B, and the system, you want an accurate prediction of that, because you're providing your best judgment to very senior decision makers in your government. And those decision makers may say to you, well, why do you think that building is a nuclear facility? Or why do you think that those tanks are going to go from there to there? And you can't just say, I don't know, the system just suggested it. I think there are different types of incentives in both of those areas, but I do think those incentives exist and are quite strong.
Okay, thank you very much. Is there any more questions? Yes? The gentleman in the front, thank you.
Thank you. Professor Deeks, suppose 50 years from now, we are in a situation in which the AI is no more explainable than it is today. In such a case, do you think that the role then of these neural nets would become less authoritative or play less of a role in especially the national security black box, as opposed to, like, do you think that the role will still be the same? Will it still be useful? Can it still be useful just based on an empirical track record of accuracy?
Yep. So, so that's a good point. I think that the answer could be yes, right? If you have enough examples of a system that you have tested out with a high, and it gets a high level of accuracy in its predictions, then that is a different way, I think, to build trust in the system. You know, so I think the short answer is yes. I think that it will be adopted potentially faster if there is some form of explanation for the weights and factors that a system is relying on. But as you say, if the system is tested over the next 20 years and produces accurate predictions each time, yes. I think one challenge there, though, is that to really test the system empirically, you may need to deploy it in the field. But military commanders are uncomfortable deploying it in the field unless they have an explanation now. So it will be slower to be able to test. You have to almost do it in a laboratory. And as we know, the results that take place in a laboratory aren't always the same results that you get once you put a system out in the field. But the empirical accuracy of a system is, of course, really important in building trust as well.
Okay, thank you very much. Is there any more questions for Professor Dix? Okay, if not, I think we'll wrap up the Q&A session here. And let's once again thank Professor Dix for his very wonderful and informative sharing. Thank you very much.
Thank you so much.
Okay, so once again, a big thanks to Professor Dix for sharing with us how the XAI can help the users and as well as the actors to enhance the efficiency and also to increase their trustworthiness towards the artificial intelligence, and also to exploring more with us regarding the circumstances and the challenges that we might have or we might encounter regarding the XAI. And now, ladies and gentlemen, we will have a short break for about 15 minutes. So after the break, we will invite our two speakers, Professor Pasquale and Professor Dix, to have a more in-depth discussion with our local scholars in the field of smart medical research and legal system. So ladies and gentlemen, please be back by 2:40. Please be back at 2:40. Thank you very much. Ladies and gentlemen, the symposium will begin shortly. Please kindly take your seats as soon as possible. Thank you very much. Ladies and gentlemen, the symposium will begin in 3 minutes. Please kindly take your seats as soon as possible. Thank you very much. Ladies and gentlemen, the symposium will begin in 1 minute. Please take your seats as soon as possible. Thank you very much. Distinguished guests, ladies and gentlemen, welcome back to the afternoon session. We will now move on to the final discussion of today. In the panel discussion, we will invite international and local experts and scholars to exchange their ideas on the potential governance issues for the implementation of AI legal system in the future from their experiences of smart medical development. At the same time, they will also join discussion and share their experiences and insights on the ethical and legal consensus which is required for AI research under the trade-off between the medical system and the industrial applications. And first of all, I would like to invite our moderator, Professor Jingyi Liu, advisor of Taiwan AI Center of Excellence, to come up to the stage. Welcome. And moving on, I would like to invite our panelists onto the stage as well. Let's welcome Professor Franz Pasquale, Professor Ashley Dix, and Professor Rongxian Jiang, CEO of Health Data Science Center of National Chung University Hospital. Professor Zhenyu Chen of Radiology, Vice President of Taipei Medical University. And last but not least, Professor Zhaotian Zhang of Graduate Institute of National Development at National Taiwan University. Welcome all our moderator and the panelists onto the stage. And first of all, I would like to invite Professor Liu and our panelists to turn off your microphone first. Thank you very much.
Okay, thank you for coming back for this. I think it's going to be a very interesting panel because we have 5 panelists with very different background and very different concerns. Because Professor Xi's moderation has been very successful in the morning, so I think I just follow suit and I borrow your template, okay, of moderation for this discussion. First of all, I would like to ask each of our panelists to use 1 minute or so, or maybe 2 minutes, to do a self-introduction and describe what you are working on, your own project, your writing, or your job about AI or related to AI, okay? And after that, I would like to give you an opportunity to raise a question to any of the panelists, okay? Especially toward the 2 international keynote speakers. And after that, I would just maybe open the floor or go to some of the questions on our list. Is that okay? Yeah. So Frank, please.
So Frank Pasquale. Frank Pasquale, and I am a professor at Brooklyn Law School, and I have worked in the area of medical AI and robotics for about 15 years now, just sort of thinking particularly about the data issues within healthcare. And one of the things that I'm very interested in working on now is this concept of data liquidity among different jurisdictions. So the idea that we both want to respect the variations that might exist between, say, different states within the US, different localities, different institutions, internationally. But we also see projects like biobanks that are dependent on some level of a harmonization of standards. And so a question of how to get to that harmonization, what institutions would be best placed to deal with that and to advance that ideal, that's my particular area of interest. I mean, I have many other projects that I'm working on in AI and law, but I think for this particular audience, that might be the one of most interest and one that would be great to delve into with the group. So thank you.
Great, thank you. Ashley Dix from the University of Virginia, where I teach primarily national security law, international law, the use of force, and government secrecy. Those are my focuses. As I mentioned, I am trying to pull together a book on the double black box, drawing from past work that I've done in thinking about the challenges of government secrecy in our system, and then also bringing in my interest in the way in which our national security institutions are going to use AI. A couple of specific areas that I've written about sort of in advance of deciding to try to pursue a book. One project looked at whether it's possible to code the laws of war into computer systems, into AI-type tools, and whether that's even the right way to frame the question. So I reframe the issue to think about the role of law in framing the parameters of an AI system, and then the role of lawyers in interpreting the predictions or recommendations that the system produces. A second project that I worked on has to do with cyber autonomy that would be enabled by artificial intelligence, and what the risks are there, both for international conflict and also for democratic accountability within the country whose systems are potentially escalating against other countries' systems. And then most recently, I've written about whether international law is going to likely be a source of new rules on national security AI. And there I'm a little bit skeptical that we'll see a lot of new international law in this area. So I'll stop there.
Okay, ladies and gentlemen, here comes the local guy. My name is Jonathan, Jiang Rongxian. I came from NCKU, which is this school. And I'm the computer science department professor, same as well. And so actually, I obtained my AI PhD in 1995, which is way back to a very long time. At that time, it's a very cold subject. No one wanted to do that. Think about 1995. And well, currently AI become big shot. Everybody's interested in that. And also, currently I'm in charge of the NCKU hospital, because I'm a CEO of the health data center of the hospital. So, which is one of the top 4 university hospitals in this country. And also, we got a lot of regulation for physicians, for medical doctors. They take advantage of this opportunity to use health AI. So I'm also interested in my personal interest in also, I'm a computer scientist. I'm also develop AI algorithm to do decision making and to help physicians to make a better decision. That's what I've been doing. Okay, hopefully I'm very happy to join us and I can share some of my experience. Thank you.
Hi, everyone. I'm Sandy Chen, the professor of diagnostic radiology. I'm from Taipei Medical University. And I'm very pleased to join today's panel discussion. Who am I? I'm working for patient imaging interpretation every day for the last 40 years. 40 years, okay, so 40. And I began to learn the AI, the imaging, the algorithm 5 years ago. Now I'm enrolled to a startup. We have product AI. So I play multiple roles. I'm a physician. I'm an AI developer. I'm a customer for some AI product. Our department using some commercial AI for 4 years. So we know all about it. But what troublesome is that we talk about data, availability of data, explainability, just mentioned about. So it's really interesting to know what the worrisome thing is. I think that the future already began since the ChatGPT. I played a ChatGPT. I think last week I asked ChatGPT for 5 academic articles that I'm interested in. It reply 5, 1 minute. Within a second, you have 5 articles immediately. Beautiful title. They give you journal name, the issue number, the page number, even DOI. So it's so real. I checked it by Google. 4 of them are fabricated. It's not really existing.
Oh, man.
There we go.
We should probably retire early, with that trend.
So always check by Google, okay? So there's a lot of issue you have to learn about how to make your, the algorithm become really useful, especially when you talk about, dealing with human life. So this is what I'm doing. Thank you.
Thank you, Professor Liu. It's my pleasure to be on this panel. My name is Xiaotian Qian, Zhang Zhaotian. I'm an associate professor of law at Graduate Institute of National Development at National Taiwan University. So I'm Professor Liu's colleague. My research field mainly focuses on health law, bioethics, and the law. And because Taiwan is such an aging society, so in the past few years, many of my research interests focus on law and aging. So I am actually writing an article where I go through like hundreds of, like thousands of court decisions in Taiwan to figure out how the courts deal with the camera in long-term care facilities. Because according to our long-term care law, the law actually allows the facilities to put the camera in some of the public space, some of the common spaces in the facilities without the consent of those residents. And the Congress idea is, as long as this camera were set, then the resident will be protected with the surveillance of the camera. So I kind of go through like thousands of the court decisions to see if how the court deal with this law and how the court deal, is there any cases related to camera in long-term care facilities. And how is it related to AI? My research, as a scholar with pure legal background, I'm really poor at math, as many of the legal scholars do. But since there's kind of wave of and popularity of law and AI, so many of my students actually they are brilliant and they are trained with the method of quantitative research. So one of my students actually can write a program to, the program helps me to go through those thousands of court decisions and finally filter out to find like there are probably like 30 or 40 decisions related to camera in long-term care facilities. But interestingly, in the end, I found that the program seems to be not that help, because I found my students actually miss a lot of important cases. And I use it with my own very traditional way, like I use the keyword and go through the judicial yuan's databases and find some of the irrelevant cases with like my own human source rather than AI. So and then another thing I found is that according to the court, I found most of the camera in long-term care facilities is actually to protect either the owner, the operator, or the work staffs in the facilities rather than the residents. Because those facilities, they have the camera and they know what kinds of information stored on their side. But residents and their families, when they request to check the camera, usually they didn't get it. The facility always reply them that, oh, we don't have the data. So that's an interesting point. So I also, I'm also interested in knowing about how AI or other care technology affects human rights of the elderly as well as the patients.
Thank you. So we will just go to our second round. So I will ask Frank to pose your question to anyone on the panel, or to have some kind of dialogue, or you can maybe fight with each other with grounds or views. Okay, yeah.
And I feel like since we have several, I mean, I have so many questions I want to ask, particularly because I mean, could I have two? I don't know. I'm going to have one that I want to direct to practitioners on the panel, sort of those who are, now in the process of, dealing with the AI in a managerial role, in a diagnostic role, et cetera, in government and other areas. And then I want to get to the point of a question about the surveillance issues, which I think are just so fascinating. The question I have for practitioners is, it's twofold. Have you seen an example of AI saving lives? And if so, what could we do in law and policy to multiply that effect, to save more lives or to improve people's lives more? Is there anything high on your list there?
Professor Jiang.
Oh, sure. Yeah. Probably not the right person to answer your questions anyway. Yeah, but I agree that's a very important one anyway. So, well, we all know that AI becomes a big shot, and a lot of scientists, engineer, or physician, they are kind of like to take advantage of this technology. So my question will be, how to motivate those scientists, engineer, or physician to protect patient privacy? How to motivate them? And is it by any kind of regulation only, or data governance rules, or some kind of the the protocol? Is there any kind of way that can be a long-term way? I mean, in terms of to motivate them to do that by themselves. Those are my questions.
This is a very important question. Once you identify one product, AI product, that apparently can save so many people's life, government should have some regulatory, some, effort to make the AI product to be used in every hospital. So, but at the beginning, it should be something like, to encourage hospital to use. But this already happened in the United States, and we're trying to catch up. For example, I'm a radiologist, and people read the abdomen CT to find out if there's an organ, abnormality. But in the meantime, the algorithm can detect the vertebral body that usually, if we look at the abdomen, we will miss the vertebral body. If somebody had osteoporosis and already had a fracture, then the algorithm will, to give a warning sign to the radiologist, this patient had fracture. So that algorithm, in the United States, they have an add-on code, CPT add-on code for that. If you use it, whatever is useless or not, I give you additional $1,050 American dollars. That's kind of incentive. If anything, any algorithm like I'm doing lung cancer screening, I'm doing in the same time using not black box, explainable technology. I can simultaneously tell you your coronary calcium score is high. You should check your heart. I'm working now. So this is the opportunistic add-on effort and value. So I think this kind of product should be identified and promoted. Promoted means giving some incentive for the industry people, because usually the industry, they have big power, the research power to do better AI job than the, university research lab. So that's different kind of thing. That's my thought. Thank you.
Thank you. Second question? Yeah.
I'll be quick, I promise. Just to respond to that, I thought I think this opportunistic add-on is fascinating. And I think that the way we do healthcare reimbursement really needs to take this into account. Because in the US, we have these accountable care organizations that give rewards when a hospital meets quality indicators. They incentivize them to save money while still meeting 33 quality indicators. But there isn't necessarily a reward for exceeding the quality indicator. And I think what you're describing with the opportunistic add-on really could lead to an exceeding of the quality indicator, raising the standard, which I think should be part of healthcare policy. It's great. My question about surveillance, which I think this is such an important project, and I mean, I think just sort of inspired by the Levy and Kilgore article on nursing home surveillance in the US, is the question I would have is, do you believe this is something that ultimately needs to be negotiated by, say, unions and representatives of residents? Or is it something that there's like a basic human right to time off camera, and that maybe we should take a more rights-based approach to surveillance in nursing homes or other vulnerable facilities?
Okay, Zhao Tian, your turn.
Question. I don't have a clear answer now, but I can further explain the current law in Taiwan. That is, according to the current law, basically the facilities need to get consent from the residents or their families. That's the rule, but we often see the exception prevails. The exception is as long as the facilities believe it's necessary, then the camera is allowed. And what is necessary, the administrative interpretation is necessary is only limited to those common spaces in nursing home. So that will result in the situation that most of the nursing home believe that they can set the camera in those common spaces without consent of the family or residents. So, the development will be whether it's commonplace or not. And but I want to challenge this kind of divinity. If we turn into necessity, then private space, there's probably a very high necessity to do surveillance if we consider about abuse or any kind of malpractice and so on. That usually happens in private space. But on the other hand, if we consider the autonomy or the human rights of a resident, then then we should go back to the consent rule. So I like the idea you mentioned. I probably will consult you more about the U.S. Nursing home surveillance experience.
Okay, thank you. So perhaps Ashley?
So I had a question, if I could, for Frank, that flowed out of his very interesting presentation, and in particular, his discussion about accountability, where I just wanted to make sure I understand the proposal and ask, I think, maybe a complicating question. So I took it that you were recommending that if a individual is using a standalone algorithm that is making recommendations to the person, that you would seek to hold the company that manufactured that algorithm strictly liable for bad recommendations. Whereas if the individual, if a doctor were working in consultation with a system and the system produces a faulty recommendation, that you would only hold the doctor liable if there were a negligence, at a negligence standard. I guess I'm wondering, I can imagine situations in which maybe a patient gets discharged from a hospital and the hospital says, here's an algorithm that you might want to use to keep track of your of your illness or of your symptoms, and you should generally, it might be worth following it. Call us if it says your heart rate has gotten to 130 or something. So, are there situations in which there is another actor like a hospital that is recommending the use of an algorithm but not monitoring that use? It seems to kind of fall between the two paradigms of left seat, right seat, doctor algorithm, and patient alone deciding to use a system. So how would you think about that sort of intermediate accountability question?
Yes, and I think that to deal with that question, I mean, it is a really tough one, and I think it's going to be increasingly relevant. And I think part of my way of thinking about this issue was to take as a baseline the idea that there are many professionals working in different roles, and to deal with a case study of AI either replacing that professional or supplementing them, right? And replacement leading to strict liability, supplementation leading to a more negligent standard. But the example you give, Ashley, is a really good one because it's an example where there probably wasn't a person doing that job before, right? They're trying to, in a way, they're exceeding the standard of care by saying, here's some sort of algorithm that is going to help you to realize when you should come back to the hospital or not. And some of our leading malpractice cases are in exactly this type of scenario where someone is, well, they're usually in the hospital, but even going out, once your fever goes above 102, once your heart rate goes above a certain level, call the doctor, et cetera. And I think in that scenario, I don't know. I have to write a new article. So it's going to give me another, this is a great gift of legal scholars to give one another the ideas for, if you give a complicated enough question. Because I think it is a hard question to sort of consider this AI taking on a function that really has not been done systematically. And I think that that's one thing that, triaging has been usually done in a more informal way, in terms of should you go back to the hospital, should you not? And I don't want to deter these sorts of things. So I don't want to create undue liability. But I also want to watch for them as potential rationalizers, things that make excuses for keeping people away from the hospital, right? That's the word that I have, so that the algorithm could become a way of saying, making an excuse for not giving someone access to a person who might be able to better, more flexibly take into account what's happening and have some responsibility. And that's where I think when you start with accountability, I think that's really key, because the problem I think for so much of AI is that it can diffuse responsibility, right? If it's used to do that. And I think if we can maintain a situation where we use the best of it, but still have someone who's where the buck stops, where the accountability finally falls, maybe that's how we get the best of it. Thanks.
Okay, thank you. Professor Jiang, do you have any questions toward any of the panelists?
Well, yeah, I can just add one more point that I got a very fancy office back to the hospital, okay? And, well, I mean, before attend that hospital, I was a professor anyway. So the reason I mentioned about that big office, because I built up the whole medical private cloud for our hospital, actually 3.5 years ago. And every day I check that, those data in and out. Every time I'm just wondering, who got the right to access those patients' privacy data? This is a very important issue. I mean, well, we do have a regulation. We have ISO 27001, and we do have our information security management system, we call it ISMS. I'm also the auditor for that. However, it looks like, well, theoretically, under consensus form, people can accept. I mean, I'm talking about the physician. I care about those physicians, and the other, physician, they care about their own patient. And sometimes when they do research under IRB, well, they can access many, many different patients' data and beyond their scope. So every day I'm just, sitting at my fancy office there. I was, every day I was wondering, wow, I hope today someone don't cross that border and access some kind of data, which is, it's not good, doing that really bad thing. So this is something that I always worry about that. Maybe someone can, can help me.
Who is going to respond? Ashley? Yeah.
It's that raises a very interesting potential parallel with intelligence and access to intelligence information.
Yeah.
So as you may know, Edward Snowden stole a lot of data from NSA and leaked it. And in the wake of that leak, I think there was an increased interest in trying to develop lots of audit tools that could understand who precisely accessed a piece of data, and sort of a master system that could see and block access by certain people or allow access by certain people. So it seems like there's a potentially interesting parallel and potentially a technological solution to the difficult question you raised.
Okay, Frank, do you have any response on this question? Because I know that you helped the University of Maryland to clarify the access right of data, right?
Well, I was chair of the subcommittee on data acquisition and consent.
Yeah.
And so that was focused mainly on the acquisition and consent and the sort of policies on those realms, but not so much as to access. But I will say that I think that technological solutions are really interesting here in terms of thinking about how you could have a tripwire to alert someone to review someone else's access to data. And so one example, for example, in the 2009 Health Information Technology for Economic and Clinical Health Act, the High-Tech Act in the US, there's provisions in the statute that give you a right to see who accessed your healthcare data. So this is called like accounting for disclosures. Unfortunately, this still has not really been implemented as a regulation over 14 years later by the Department of Health and Human Services. So, but the law is on the books, you know. So I mean, I think that if you had an activist OCR, or if you had someone that was put forward a complaint that they weren't getting it, you would get a corrective action plan that would require this sort of access. But what was strange to me about it was that when we were discussing it, like, I don't know, probably 8-9 years ago, what I heard was that vendors hated this because they did not want to put into their system the metadata of adding to a medical record a record of who accessed the record, right? But it seems to me that like those sort of audit logs should be de rigueur, and it seems like it's relatively computationally probable. So I think that, you know, having both that sort of accounting of disclosures, random audits, and tripwires, where, for example, if you have a doctor who lives on a certain street and that doctor asks for the records of people also on that street, that looks like someone who's nosy, right? And that actually is a case out of Louisiana in the US. There was a nurse who just was nosy about what illnesses her neighbors had. And so those sorts of things I think are, or like celebrities. We've had cases in the US where celebrities, you know, so you audit that. So I think that there are some practical ways of making sure that that doesn't happen. But it's hard to incentivize, and it is an extra cost. Yeah. Thanks.
Yeah, so Professor Chen, you have any questions?
About the topic beyond the medicine. I mean, I actually just mentioned about the Social Security Administration, that kind of stuff. I heard that some country already use this AI system to give every citizen credit. If you are a jaywalker 3 times, you know, your score down, and you probably cannot use your credit card. If continue down, you can't buy any food in the supermarket. So it's really creepy. How do you comment on that?
So actually, and then I think Frank has something to say about it, because you have written about that, you know, in your book. Yeah.
So Frank will have a serious answer to that point, but one thing I'll say is I lived in Baltimore for a little while, and I have never seen so much jaywalking in my life. Every day, every citizen jaywalking left and right would have a very low social credit score.
Frank?
Yeah, I'm happy to say, I'm really happy to say that the translation. I do have a section in my book, in a chapter called Machines Judging Humans, that is on the social credit score. There's a section on it, and just was released in the translation here today, so I'm very happy about that. I think that I'm going to preface this by saying, those who study the social credit score system and who are translating it will very frequently say, don't worry about it, that it's really about sort of like debts and, you know, arrests, and it's binary and it doesn't have that much AI or scoring in it yet. But what I excavated for the book was at least some journalistic accounts that sound very much like what you're describing. And I think this is, and they're very worrisome to sort of think that there could be a score or someone, their status would be lowered, or if they do something that automatically they can't get on a train. And the language, I think, of the original 2014 outline of a proposal for a social credit scoring system said something along the lines of, the goal was that the honest person can traverse the world, whereas the untrustworthy person cannot take a single step, right? That's a pretty scary articulation of a vision. And I think that's one reason why the European Commission, with the EU AI Act, one of the very few things that they have a red line prohibition on is the type of social scoring you're describing, where there's like a single score put forward by a governmental entity with respect to someone's, ability to respect to their trustworthiness or general level of social value. In my book, what I have said, because I am sensitive to the claims that critiques of this social credit system have gone overboard in some places, I have tried to outline the three things that should never be in a social credit system. And one, I think, is punishment based on what punishment of your friends, right? Like a collective punishment. So there should never be a system where you get punished because of something your parents did. And there actually was an article in a Chinese newspaper at one point that was, the title of the article was, the children of those who run red lights should still be able to go to school, right? It's a very interesting sort of article, right? That was a legal article. The second thing that I would say is, like, on these sorts of things is that there has to be an avoidance of punishment for speaking about the system itself, right? So the ultimate social credit scoring system, it could become incredibly powerful if it could lower your score just for your questioning the score being lowered. Right. And this was the premise of the Black Mirror episode Nosedive.
Yeah.
So I recommend seeing that. And I think I have a third proposal, but I'm a little jet lagged, so I forget the third one. But it is in the book. So, but thank you for asking about it. Yeah.
Okay, great. Zhao Tian, your question.
Yeah, my question for Professor Pasquale and Professor Dix is about ChatGPT. Since everyone is talking about ChatGPT, and ChatGPT passed the bar exam as well as a license for medical practice. So how do you think that, for Professor Pasquale, how do you think that ChatGPT influence the medical practice as well as a doctor-physician, doctor-patient relationship? And also for Professor Dix, how do you think that ChatGPT will influence decision-making in national security?
Thank you. It's a terrific question. And I mean, I think one thing that, I actually learned this from Professor Xu earlier, which I think was quite a helpful clarification, is thinking about the difference between a language model and a knowledge model, right? Sort of thinking about it. And I think that one thing that the doctors may need to train patients on is to say, this is something that is extremely gifted at producing fluent sounding answers. But as Professor Chen mentioned at the beginning, it also can just totally make things up, right? And and therefore, to take it with a grain of salt. The second step I want to take is, I think that in the future, what it will be doing is they will try to make a transition from being a language model to a knowledge model by bringing in medical literature. And this was the original promise of IBM Watson, right? The promise, if you looked at IBM Watson literature from 7 years ago, they said, a doctor, there are 50,000 research papers published a week or something like that. A doctor has no hope, even in their specialty, so we'll digest the information for you. And Watson has really had a tough time. I mean, Dr. Eric Topol, Gary Marcus, they all use Watson as an example of a failed promise of AI. The hope with the language model is that you could integrate reliable literature into the model so it becomes more of a knowledge model by a fine-tuning. But I still think we're a long way from that. I don't know. I mean, I think it's going to be hard to do it. And that may be a project. The question to me becomes somewhat of, is that a project of 5 years, 10 years, 20 years, et cetera? And if you'd asked me about self-driving cars 5 years ago, I would have said, oh, I think that'll be a solved problem, within the 2020s. I don't know yet. I don't know now, if that will be. And I think the question might be, is that sort of very strong, valid medical advice giving more like translating something, or is it more like giving advice? And perhaps even with translation, I'm assuming too much about machine translation by saying that. But or is it more like driving? But great question. Thank you. Yeah.
Ashley?
Sure, I agree. It's an excellent question, and I think it's such early days that it's very hard to know how it will play out in, for example, our military setting. I think part of the answer will depend on what Frank just mentioned in sort of the quality of it. Where does the quality go from here? It was introduced at a particular level of quality. Is it going to get better? Is it going to get worse? Yeah. So one thing the military might decide to do, if it proves to be quite a bad system, is potentially ban the armed forces from relying on it for anything. This is all just me speculating on my own. At the very least, I think armed forces would want to train their officials and their soldiers about it and what it is good for and what it is not good for. You could imagine, this sounds maybe a little weird, but sort of educating forces about different quality of news sources where, you know, military directives and information provided by your own commander is the sort of highest quality information and data. Articles from the New York Times are sort of good quality, and then worse comes to worse, you can't get access to anything else, then maybe you could use ChatGPT to ask a question and get answered. So I don't really know. I think concerns about something like spoofing and ChatGPT is always going to be a sensitivity for democratic militaries. But I think we're at very early days in knowing how this is going to play out. And we're just now, I think, at our different law schools starting to see our deans convene meetings to talk about how ChatGPT will affect the kinds of exams that we're allowed to write and so on.
Okay, thank you. I think we are actually running out of time, right? But so I will just proceed to our concluding part of this panel. I would like to ask every panelist to spend like 1 or 2 minutes to say something about what he or her, what is his or her prediction or observation on medical AI. The question, and focusing on 2 sets of questions. What is the most promising aspect of medical AI, and what is the most worrisome aspect for the development of medical AI? And with that in mind, what is the most urgent ethical or legal issues in terms of the research and the use of medical AI, and what should be done, okay? Or what kind of regulation we should have on the research and use of medical AI? So, Frank, okay?
By the way, this would be a great tool of great task for automation, was just be automatically turning on mics. That'd be a good, because I always forget. So, and I say that as a joke, but I actually do sincerely believe that, and it's one of the themes of my robotics book, is that these sort of simple things is like our lives should be much easier than they are, right? You know, I think in terms of just if you think of anything that annoys you on your phone, that should be automated away. You know, and so those sorts of things. So that's one hope of mine. But let me give the most positive and then the most worrisome. The most positive, I think, is a world where genuine pattern recognition is truly mastered, right? The examples of dermatology, pathology, radiology, those sorts of disciplines, perhaps ultimately merging into a medical imaging discipline or medical knowledge discipline. This is what Saurabh Jha and Eric Topol have called for in JAMA, Journal of American Medical Association, a few years ago. That's super exciting. Right, to have that possibility of saying, we will never miss anything, or it'll be incredibly rare for us to miss something because we have such a great data set of past problems, and it is so good at this sort of superhuman pattern recognition. So I hope we see a lot of investment in that. On the downside, on the negative side, my biggest worry is computational therapy being introduced as a cost-cutting measure for mental health. Because I think that's a clear and present danger. I think that there is a huge, especially in the post-pandemic era, there is an enormous demand, unmet need for mental health care. And there's a lot of pressure now to say, look, you could go to see a therapist for $80 a visit, or you can get some app online for $2 a month. The economic case is clear, right, in that sort of situation. And particularly in market-based healthcare systems like the US, that's a clear and present danger. And it's also, wherever there's cost cutting, it's going to be something that could come up. So I think that, trying to develop some rules that give people, say, a right to talk to a human about some issues they might be having might be one. But of course, I have to admit, I don't know much about internationally the nature of mental health care. And so I would have to learn much more about the context here and other places to understand if this would be a danger or not. And also, I have to give the possibility that it does, when there's absolutely nothing on offer, it can very often be better than nothing. But those would be my responses. Thanks.
Thank you. Asher?
Thanks. I will answer a slightly different question than the one you asked because I don't have really healthcare experience. But I think as a general matter, democracies really need buy-in from their citizens about these kinds of tools, and the way that we need to proceed here is for people to really develop informed views about the costs and benefits of these systems for ourselves. And that, I think, starts with education. I think it starts with meetings just like this one, where we're talking across different segments of the academy and training, so that we can understand better what tools are potentially on offer and understand why we either favor or disfavor the use of particular tools. And so, again, what the costs and benefits are. So I'm glad to be able to be a part of this because I think it's helping move that forward.
Okay, sure. I think 1 minute probably not enough for me, but I agree that Frank just mentioned about the most promised area or most optimistic. I agree that, but I want to add one more point. I believe for most of the physicians or medical doctors, they are very busy. So one day, those kind of commercial product or solution or medical AI, if they can save their time, save their tedious work, it can integrate together, that could be a that's what I think is the most promised area for that. And on the contrary, I think the thing that I'm always afraid of that, or I worry about that, is some kind of, people call that the one-stop function, or one, just hit one button and you get everything done. And that's terrible. That kind of thing is always terrible because, the devil is hiding detail. There's we went through this Y2K problem. It's just because of the clock problem, and those are many detailed things that may cause disasters because of if that is still black box. So I don't trust that kind of one button function and do everything for you in medical AI, and think that could be the most terrible thing I can thought. Thank you.
Is now that because we know the global agent, the pandemic, new infectious coming in. And so the healthcare resource, the manpower will be 20% short in the next 5 years. So I think AI technology is timely. So the exciting thing is that, you can, give patient more time to interact with the healthcare professional, especially doctor. Taken as a radiology, when did you see a radiologist, to come to the scanning room to talk about you and your disease?
Never.
Never. Most of the time, I read the emergent patient, I never see them. So that's kind of a distance. So we need some more time, more space, and I think AI is a whole because I'm developed some of them. The second thing is that I think there's some worrisome thing is the security problem that if someone can to crack your algorithm and to change your some coding, and the output become inaccurate, or even to do harm to the patient, well, there will be a big problem. So there's a lot of things going on in the regulatory aspect or some the AI research. So I think it's very interesting from now.
Thank you. Zhao Tian.
I will answer this question in the context of a Taiwanese law. I think there are like 3 issues I think that have been widely discussed in Taiwanese legal literature regarding medical AI. The first one is about regulation, especially categorization, whether medical AI should be considered as a kind of medical device. And if the answer is yes, well, should there be a kind of different standard of review in terms of medical device? The second issue is about liability when it comes to medical malpractice. Should it be considered under the context of product liability? And how should the physicians or the institutions need to be responsible for it? And the third issue is about the data, the share and the use of medical data to facilitate and to help develop medical AI. I think all the 3 topics are really significant, and they are all in response to the calls of AI developers and users. And what I think that if you ask me that which one should be urgent in terms of law or regulation, I would say the third one is probably the most urgent, as Professor Wu mentioned earlier in the morning, that there's a legal vacancy in terms of healthcare data. But the other part I think is missing in our in Taiwanese legal discussion. I think it's about the ethical concerns. We need to integrate those ethical concerns of AI into all these 3 very practical issues. For example, whether AI can mitigate health disparities, and or whether there is enough transparency in those AI design and data collection. So I think what I suggest for the Taiwanese law is we need to not just dealing with those practical issues, but we need to integrate and strengthen our ethical concerns in those regulatory and the policy debates.
Okay, thank you. So I think it's about time for us to just conclude today's panel discussion. And I would like to take this opportunity to offer our thanks to our 2 international guests and the 3 local panelists for what they have done on this panel and all the wonderful jobs, okay, they are doing. Okay, thank you very much. Yeah.
Thank you very much, Professor Liu, for moderating this session and the lively discussion. And before we close today's conference, I would like to ask Professor Liu and all our panelists to come to the center of the stage for a group photo together. Okay. And for our guests, you can take your mask off for just a moment. Thank you very much. So it's really of great delight to have our leading experts internationally and locally to join this conference today. Okay, so everybody, let's gather closer. Okay, let's look to the front. Okay, ready, set, smile. Okay, for the next one, let's thumb together. Perfect. Okay. Thank you very much. Thank you very much. Okay, so. Oh, okay, so for now, we would like to also invite Assistant Professor Gao to also join us on the stage. And also, I think Professor Xu and Professor Zhan can also join us on the stage. We can have another round of photo together. So now we want to invite all the distinguished guests that are present with us today here to join us on the stage for a group photo together. Okay, so for our guests, you can take your mask off for just a moment. Oh, and also Professor Chung, please also join us on the stage. Okay, so everybody ready? Okay, let's look to the front. Okay, smile. Okay, for the second one, let's thumb up together. Perfect. Okay, thank you so much. Thank you so much. Yes, so I think we all agree that ever since the outbreak of the pandemic, we rarely have a chance to have perspective exchanges with international guests in person. So today it's really of great pleasure and delight to have Professor Pasquale and also Professor Dix to join us for this remarkable conference. And as I'm aware, you have visited Taiwan before. Yes, so I hope you still feel the vitality and also the hospitality of this beautiful island. So thank you very much. So ladies and gentlemen, this concludes today's symposium. And with all the remarkable speeches and lively discussion from our presenters, I'm sure that everybody has a very fruitful time. So that will be end for today's symposium. And we wish you have a fruitful time. And once again, thank you for joining us for your participation. We wish everyone prosperity, health, and happiness. And also please remember to bring your personal belongings before leaving the venue, and also to return the interpretation device and retrieve your personal ID before leaving. Thank you so much. Thank you. Goodbye.